This hearing is the matter of case number CFI 106-2021 before Justice Sir Peter Gross. The claimant is represented by DLA Piper Middle East LLP. Lead counsel is Mr. Lord Marks KC. The defendants are represented by Taylor Wessing. Lead counsel is Mr. Nicholas Carnell.
Thank you. Good morning again. We are down, I think, for 4 hours, which is a maximum. How would you like to divide the time?
Your Honour, I think we've had a brief discussion about this. Essentially what I think we're going to do is that I'm going to make my application on behalf of the defendants, which was the first in time. Lord Marks is then going to make his application. Now, inevitably, there is an overlap between the two applications, and there is quite a lot of common material between them.
Yes.
And to perhaps just develop what I've said very slightly, I was proposing to deal with the claims as initially put against D2, and I was also going to comment to a degree on the fraud allegation, but I was going to leave it to Lord Marks to make his application in respect of the tortious interference point. I would then reply to that, and were he so minded, he could reply to me. I should, before we go much further, Your Honour, just also make one apology, which is that we've been having some rather grim internet issues in this office over the last week. That has meant that we've been unable to file a costs statement.
Sorry, it's no waste time on that. That's the least of my concerns this morning. Then let's waste time. This is meant to not asking for a submission at the moment, just trying to work out how we're going to use the time and to make sure both sides have enough time. You say you want to focus on the claims as initially put. Aren't we really interested in the way Lord Marks is now trying to put it, and whether he's entitled to or not?
We are, and I'm very happy to make all of my submissions, and it won't actually in the aggregate take any longer. So I'm very happy to do it that way, Your Honour.
Yeah. Otherwise, we're spending a lot of time. What there was, what there now is. What I'm interested in is the way it's currently put, and whether that can or should go anywhere.
Well, that suits me absolutely fine.
Thank you very much. Now, timing. As you couldn't agree the top three authorities, let's make sure we can agree the times. I'm very disappointed that couldn't be agreed. Surprising. Don't react. It just doesn't reflect well. When one's asked a neutral question, what are the top three authorities? I expect that to be agreed. Anyway, timing, gentlemen.
I'm going to be about an hour.
Thank you. And Lord Marks?
I expect I'll be an hour as well, and I also propose to deal with the case in the round. I was going to deal with my amendment application first and then respond to some things that go specifically to jurisdiction.
Yeah.
I think an hour is fine.
Okay. Basically, if it helps you, we'll take a break at some stage if we need one, but if Mr. Carnell's about an hour, we might have a short break, then Lord Marks, then any replies.
That sounds very sensible.
Good.
I think I might have been a bit optimistic at now, actually. I may have been more than that.
Okay. Right. Mr. Carnell, away we go.
Thank you very much, Your Honour. Well, as you know, we have two linked applications here. The first of those is to have the second defendant, Dr. Affan, removed as a defendant, and the second is the claimant's application to amend. I will take you to the draft amended claim form in a moment, but as you will recall, this was originally formulated simply as a claim in debt against both the first and the second defendants. Yeah. The claim as now put seeks to add claims under Articles 84 and 162 of the Companies Law, and a claim for tortious interference. Now, you will recall, and I don't think I need repeat, the test for an amendment and the test for what is required in order for that amendment to be granted. But that is something which is, for your note, Your Honour, set out in paragraph 1.4 of our skeleton, and it involves the claimant showing that they have a real rather than a fanciful prospect of success. And I'm going to come back to that mantra frequently, because it's our position that the claimant has failed at every step to show that it has a real rather than a fanciful prospect of success. You'll also recall that when we were before you on the 16th of June this year, you had, prior to that hearing, asked some questions. And in answer to the last of those questions, question 6, you had said, and in our view it was a very sensible observation, that it made sense for the parties to deal with both limbs of the present issue at the same time. And you made the point, quite frankly, that it was for the claimant to demonstrate exactly what it was that it was contending. And with that in mind, you directed that the claimant should serve a draft pleading with a skeleton in support. And you will also note that the claimant served a witness statement by Mr. Doyle of that company. Now, just for your notes, Your Honour, the particulars are at H26 to H37. The skeleton in support is at H15 to H25, and the witness statement of Mr. Doyle is at H38 to H76. I'll be taking you to bits of those in the course of the next few minutes, but it might just be helpful for your note to have an idea of where these things are to be found, because the bundle is quite significant. It's actually quite easily navigable, but it is nevertheless a pretty titanic piece of work. And in response, the defendants filed a draft defence, a skeleton, and a rather smaller witness statement by Dr. Affan. And these are in the bundle starting at page H585. Now, the headline position I'm going to develop over the next few minutes is, as we've said in our skeleton, that the claimant had an absolutely free hand to set out its case in as much detail as it wished, and we say it has manifestly failed to do that. So let's start, if we may, by going to page H13, and I am hoping that the redoubtable Mr. Blakeway is going to be able to share his screen, and will be able to go to that document on the screen. Is that going to be possible, Paul?
I believe that should be showing now, if everybody could please confirm.
Not at the moment.
What would you like, Mr. Cornell? Which page was it?
H13.
We'll probably get there. Page 13.
It's, yes.
The draft re-amended claim form.
Correct.
Right. And there.
Very good. And you will see, if you look the middle of the page, sorry, if you look at the top of the page, you'll see that there is a claim for an amount of 103,445,360. And the claim was originally formulated as a claim in debt, and as amended, it's a claim for damages for breach of contract and or as against the second defendant pursuant to Articles 84 and 162, and or damages for tortious interference with the subcontract and the addendum. We can break that down into 4 distinct claims then. First of all, there's a claim in debt. Secondly, there's a claim in breach of contract against both D1 and D2. Then, as against D2 only, claim pursuant to Articles 84 and 162, and or a claim for damages for tortious interference with the subcontract and the addendum. I'm going to deal with what I'm going to call claims 1 and 2, which are the claims of damages, sorry, the claims in debt and damages for breach together. And I'm then going to deal with the claims under Articles 84 and 162, and the claims for tortious interference together, because those again raise linked and associated points. And I can deal with what we can call claims 1 and 2 in fairly short order. First of all, it's entirely unclear how a claim in debt can arise against D2 at all. It's a remarkably precise figure. We have no idea at the moment how this figure of 103,445 and change is comprised. We're not told in the draft particulars of claim how that figure is reached, and more to the point, we're not told how a claim in debt can arise against D2 in any event. Bear in mind here, Your Honour, the first defendant was a subcontractor engaged under a construction project, and D2 was its director and manager. So it's entirely unclear on the face of it how such a claim arises against its director and manager. It's equally unclear on the face of it how a claim for breach of contract arises against D2. Now, we'll come back to the idea of whether or not there might be liability for procuring a breach of contract or tortious interference. But as against D2 himself, there is simply no contract, ergo no claim. So far as claims 1 and 2 are concerned, your starting point is that there is no claim. Now, this gives rise to the first difficulty which the claimant has. DIFC is a gated jurisdiction, as we all know.
Is a what? Sorry,
a gated jurisdiction. In order, sorry, it's probably my shorthand. In order to get before the court.
No, I just didn't hear. Sorry.
I beg your pardon. In order to get before the court, you need to get through the gate.
Yeah. Yeah.
And clearly the claimant doesn't. Now let's have a look then at the relevant bit of the judicial authority law. And let's see if we can find document I-200.
Yeah. Just pausing there.
Yes.
Of course, if there's no contract, then that's, or no, I don't want to get hung up on the test for the moment, but no properly arguable contract. I'm alive to Chief Justice Zaki's test.
Yes.
If there's no properly arguable contract, then the gateways don't matter.
They don't.
If there is there a separate point on the gateway?
If there is, then we get into Article 5A2, which in our respectful submission doesn't help you either.
Right.
So
I
I may be being a bit belt and braces about this, but it seems to me to be very clear if we look at the top of page I200, and you'll see what you'll see Article 5A2 set out.
Yeah.
The Court of First Instance may hear and determine any civil or commercial claims where the parties agree in writing to file such claims or actions with it, that being the IFC. We don't need to look at the next few words, provided that such agreement is made pursuant to specific, clear, and express provisions. Well, that just doesn't arise. So on that basis, we don't get through the gateway, and on that basis, there is no jurisdiction to hear any such claim against D2. Now, that really only leaves the claimant with the so-called necessary and proper party test. Now, you'll probably recall, Your Honour, that when we were before you last time, we'd received extensive submissions from the claimant in relation to a case called Nest Investments. Now, I'm going to be interested to hear from my learned friend as to where we are with Nest Investments, because there is no reference in his draft particulars to Nest. There is no reference in his skeleton to Nest. We have to go to paragraph 25 of his responsive submissions, and for that, if you can find page H733.
H733.
H for Harold.
Yeah. 733.
733. And it's paragraph 25 of those submissions. We're told that the claimant has not abandoned its case on Nest. The claimant maintains its reliance on that case. D1 is properly sued within the jurisdiction of the IFC court because of the provisions of clauses A10 and A11 of the addendum. Well, we accept that D1 is properly sued and that the court has jurisdiction to hear cases against D1. And we're then told D2 is a necessary and proper party to this litigation and is therefore, for all reasons advanced hitherto, properly joined as a party. Well, that's not very helpful because we're not told on what basis D2 is supposed to be a necessary and proper party, given the case now advanced. So we would rather like to hear from my learned friend on this point, because it does seem to me that it's a point on which you should receive some guidance. And frankly, we would like to hear some guidance, because at the moment we don't really know what the case against us under Nest Investments is meant to be. But assume for these purposes that Nest Investments is relevant and that Nest Investments does give rise to a necessary and proper person test. You will recall that the issue in Nest Investments was whether a partner in the defendant, which was Deloitte, should be joined into the proceedings. Now, the position in Nest was that the second defendant in that case, Mr. El-Fadl, was the moving force behind the alleged criminal conspiracy which had led to the claim. Without Mr. El-Fadl's involvement, there would have been no such claim. So he was very much front and centre in everything which was being maintained. That's not the case here at all. Now, as against Dr. Affan, the only claims that we can see relate, on the one hand, to the security checks, about 16.8 million, and on the other, the so-called Qanun issue, which is about a further 1.6 million. So that, by my rather crude arithmetic, amounts to approximately 17% of a claim for 103 million. So it's a pretty modest proportion of the whole. And on that basis, we say that Nest is entirely distinguishable. And as we'll see in a few minutes, even the claims in respect of the security checks and the Qanun claim, when you scratch the surface, they disappear.
If underlined, the claimants have a sufficient case that there is a contract, or that there is contractual liability, on the part of D2, wouldn't that be a case where you would want to invoke the necessary and proper party rule?
Well, the first thing to say, Your
If
Honour, is
there's no arguable contract, of course it falls away. But if one reached a conclusion that he was liable on the contract for whatever reason, surely that makes him at least a proper party.
well, two things to say here. The first is that there is no pleaded case, that there is a contract with D2.
Well, that's slightly tendentious, if you don't mind my saying so. He's set out in his draft pleading the nature of the case that he's going to be advancing.
He has set out the nature of the case he is going to be advancing. At the moment, he is not advancing a case to the effect that there is a contract with D2.
Okay, well, we'll see what Lord Mark says. I'd understood him to say that at least under Articles 84 and 162, he may be right, he may be wrong, there was contractual liability as well as statutory duty.
That is not how I have understood.
Well, I may have misunderstood.
And I don't see, I don't, and if I can put it this way, we have not seen anything to suggest that there is a contractual duty.
Okay.
And we have not seen anything to, I will wait and see what Lord Marks has to say on that subject.
While we're on what Lord Marks is having to say, what is interesting in the particulars of claim is there's no allegation of fraud or deceit. If you look at H13,
well, that with respect to Lord Marks is not quite right, Your Honour, because if you look at the Articles 84 and 162 points, and I'll take you to those in a minute.
It's wrapped up. It's as part of 84 and 162.
Yes, okay. Those specifically raise the issue of fraud.
Yes. No, you're right. Okay.
So I don't. So I'd love to take that point, but I don't think I can.
No, I don't think you can. I think you're right. Thank you.
So tying the threads together on claims 1 and 2,
yes.
We simply don't understand how a claim in debt can be advanced. And as far as a claim in contract, there doesn't appear at the moment, at least on our understanding, to be such a claim. And in our view, under the terms of the judicial authority law, you simply don't have jurisdiction to hear claims against D2. So that was what I wanted to say on claims 1 and 2. And from there we move on to the third and fourth limbs, which are the Articles 84 and 162 claims and tortious interference. Articles 84 and 162 of the Companies Law and tortious interference. Now, we need to first of all look at what Articles 84 and 162 say, and that is I-234.
Thank you.
And what you will see is you'll probably need to scroll up slightly. I'm not sure whether this applies to yours as well, Your Honour. My bundle seems to be marked CI234, but I don't think anything turns on that.
No, I'm there. This is the 2015 law.
Quite right. And it says the manager of a limited liability company should be held liable towards the company, partners and third parties for any fraudulent acts committed by him and should compensate the company against any losses and expenses incurred thereby due to misuse of his powers or violation of applicable law, company's MOA or manager's appointment. And you'll see that that relates to the manager of a company. And if you go down to the next page, 235, you will see that Article 162, which is at the bottom of that page, says members of the board of directors shall be liable towards the company, shareholders and third parties for fraudulent acts, misuse of power, if there was any violation of the law, company's AOA, which is Articles of Association, and mismanagement, and any provisions made to the contrary hereof shall be null and void. That is what is provided under UAE law, and so we have this. We have the task of determining what, as a matter of UAE law, is meant by fraud. We're not concerned by what is meant under anybody else's law. This is a matter to be determined under the laws of the UAE. Now, the test which the claimant must therefore satisfy is that these are matters which, as a matter of UAE law, constitute fraud. Now, the first thing to be said about the claimant's approach to this is that it aligns fraud with good faith. Now, I will come to this when I come to deal with the cases, but since this is a UAE law contract, it is accepted by the defendants that there is a duty of good faith, and that is found in Article 2461 of the UAE Civil Transactions Code. So we can certainly look at what is meant by good faith in this context, but there's no doubt that obligation does exist under UAE law, and we don't contest that. However, what we say is that breach of an obligation of good faith and fraud are different. However, that's not the way the claimant puts it. And what I'd like to look at first of all is H34.
Yeah.
And I'd like you to look in particular at paragraphs 34 and 35 of the draft particulars served by the claimant.
I'm so sorry. It's entirely my fault. Which paragraphs?
34 and 35.
Yeah. It's getting there.
I'm sure it's more efficient, Your Honour, for you to read those to yourself rather than having me read those.
Thank you. Very
But it's essentially what we're told is that breach of good faith is essentially tantamount to a fraud committed under Article 84. And you should then, please, and it's probably easiest if you just scroll down, go to page H40, which is Mr. Doyle's statement, paragraph 2.1. Sorry, paragraph 2. Now this is what comes with having. Sorry, it's paragraph 2C. It's entirely my fault. Part 3, an overview of my personal dealings with D2, my understanding of his role as the controlling mind of D1, and examples of his apparent fraudulent and dishonest (bad faith conduct and behaviour). So Mr. Doyle, not a lawyer, but no doubt having his pen guided, is quite specifically seeking to elide good faith with fraud. Now, when I come to look at the various cases, and I'm going to do that at the end because I'm going to do it pretty briefly, we'll see that even on the English authorities, good faith and fraud are entirely understandably regarded as being very separate ideas and separate concepts. So let us look then quite quickly at how UAE law define or treats fraud. Can we then go to, I think it's page I359. Actually, could you please scroll up to I357, please? And this is a report of a decision of the Dubai Court of Appeal. And I'd just like to read the first 2 lines. Translation isn't brilliant, but it's clear enough. The fraud crime may not be established by mere statements and allegations. The law necessitates that the act of lying must be accompanied by external material acts, making the victim believe in their authenticity. And I'd then like you to just go down to the second case which we've referred to, which you'll find at I359. Similarly, very short and perhaps equally cryptic. Fraudulent methods may be of such a degree of ingenuity of plotting that it permits the deception of a person of mediocre (average) intelligence, and the victim must not be irrational or naive to believe all the lies he hears or receives. It's perhaps a little lost in translation, but what you will see is that the UAE courts have said that it's not enough for there simply to be statements. There must be actions as well as statements, and those need to be of a fairly high degree of gravity in order to deceive the person who is supposedly taken in by the fraud. Our position on this, Your Honour, is that those are the tests which you need to employ And that is what the claimant needs to show and hasn't. So,
Is it a different test to the test for deceit in English law?
I think it is different. I think it is different.
In which respect?
Well, I think in this case, the person committing the fraud needs actually to commit actions as well as simply making representations.
I doubt it somehow, but imagine a thoroughly dishonest, fraudulent misrepresentation where there's no defense that it was honest. It's unscrupulous, intended, and the victim relies on it and loses.
Mm.
Are you actually saying that that's not covered? I'd just be surprised if that was the case.
Well, I completely take on board what you're saying, Your Honour. I'm simply taking you to what the words in the decided to buy cases say.
I'm just trying to make sense of it. Doesn't it mean you can't just allege fraud? You've got to show there's been something which has caused damage or deceit or whatever, or on which you've relied or something of that sort.
Well, I think that is definitely right. Yes.
In which case, I may be wrong, of course. In which case, the statements or allegations, it's not ruling out a misrepresentation case. It's just saying you can't just come along and shout about fraud. You've got to show that there's been something which was intended to deceive you and did deceive you, and so on and so forth.
Yeah, well, that's exactly that. I think is the case.
In which case, and with respect, the court's statement is admirably concise. We're not very far from deceit.
I don't think we are all that far from deceit. I agree with that. My point, Your Honour, is that is not that's not the way that the claimant puts it.
You have a separate point, which is that fraud and breach of good faith cannot be conflated.
That's exactly right. Yes.
And I follow that point.
Yes.
Anyway,
all that I'm saying, Your Honour, is that the way in which the claimant has put its case does not accord with the way in which the matter has been approached by the Dubai courts, and therefore they have applied the wrong test. And on that basis, much of what they presently say would appear to us, at least, to fall away. And stating the obvious, I'm afraid, but we can only deal with the case that is put against us. So that takes us quite nicely, I think, onto the two matters which the claimants primarily rely upon as demonstrating that there was allegedly dishonesty and fraud on the part of D2. I'm going to call those the Canoon issue and the checks issue. I'd like you to go first of all to paragraph 6.2 in our draft defence, and that's H607. Now, I'm going to invite you in a moment to read a certain amount of this pleading, because I don't think the facts themselves are particularly disputed, but their effect is. Now, on the claimant's case, what happened in very brief terms is that a sum of approximately 1.8 million dirham was paid to the defendant for the purposes of, among other things, paying Canoon, who were a supplier. Of that sum, it is said that only 200,000 dirham was paid to Canoon. And I'm not sure whether it's suggested that the claimant pocketed the remaining 1.6 million, but it certainly suggested that the second defendant did not pay that money to Canoon, and that in and of itself constitutes dishonesty. Now, we have set out the position at some length in the draft defence, and the important paragraph to read, I think, is paragraph 6.3, because that sets out the sequence of events. Now, what happens here is that the addendum agreement was dated the 17th of December. That agreed to pay a sum of some 15 million dirham to the defendants, subject to substantiation. The defendant, part of that sum, it did not pay all of it. It only paid, in fact, about 13 million, or possibly slightly less than that. And only at a later point in time, some 50 days after the payments were started, did the claimant indicate that it required payments to be deployed in a particular way. Now, by that time, hardly surprisingly, the defendant, or rather D2, running the business, had paid the monies as he saw fit. Now, D2, as the manager and the director of D1, is entitled to make use of monies that he receives as he thinks fit in order to run his run his business. That's his choice. The claimant only directed how that money was to be deployed at a later point in time. So we say the Canoon allegation simply does not get off the ground. And on that view, you can disregard that. We can then deal very quickly with what we'll call the proper substantiation point. I've said to you,
the same point, or was that the second? There were three allegations Lord Marks, I think, focused on. One was this one.
Yes.
For the second, and then there's the checks.
The second is the proper substantiation point.
Yep.
And I can deal with that in very, very quick order, which is that, and there is reference to this in the Mid-Essex case, to which the claimants are going to refer you, but it's made very clear in the Mid-Essex case that simply putting forward a misconceived assertion as to an entitlement does not, in and of itself, constitute a breach of contract. For Lord Marks's benefit, it's paragraph 141 in the judgment in Mid-Essex, and he may want briefly to take you to that. But what we say is that the substantiation or lack of it cannot, on any view, constitute even bad faith. This is a construction contract. In any construction contract, there will be arguments about the entitlement of a contractor to be paid. That is the, and I'm not, I hope, giving evidence here, but that is the nature of this sort of dispute. That is simply the way things happen. And to inflate that into something more sinister, we say is just hopeless. I'd like to spend a little bit of time then on the security checks, because these are really very much the high watermark as far as the claimants are concerned. There's not much debate about the underlying facts. It is accepted that D2 provided checks with a total value of 16.86 million dirham. It's also accepted that on the 26th of June 2019, those were presented and they were returned dishonoured.
Was June 2009, June 2019.
Correct. 26th of June.
26th June.
And it's quite it's quite
When were the
important.
checks issued? Just can you give me the date?
They were issued, I believe, in the previous December.
You believe?
I can confirm. I can get back to you on that.
No, it's quite important as I understand your point, and I do understand it. You say the relevant test is, did he have an honest belief at the time the checks were issued that they could be paid?
Yes.
So we need to establish the date of issue, don't we?
I think we do, and I will certainly confirm that. But
it's listed somewhere. Somebody's document runs through when the checks were issued. May even be one of yours.
It may even be one of mine. It is certainly the case that and I will take you to that in a moment.
May I help here?
Yes, you may.
So the first check was at the time of the date of the addendum, it was the 17th of December.
Yes.
Then there was a second check, I think, on the same day. Then there was one on the 20th of January of 19, and one on the 10th of February 19. And for completeness, the letter from Mr. Affan saying that there were no funds in the account was the 24th of April.
And that's at H371, and we'll go to that in a second.
Thank you very much.
And I'm grateful, Lord Marks. It's accepted by the claimant that the relevant state of mind is that of D2 at the date that the checks were written. And if you want, I can take you to it if you like, but I don't think it's disputed. It's paragraph 17 of the claimant's reply submissions, and for your note, Your Honour, it's H731, and they accept that is
H what?
H for Harold 731.
Yeah.
And as far as the claimant, as far as D2 is concerned, in paragraph 1.4 of his second statement, and that is at H618, and I think we probably had better look at that. Do you have that, Your Honour?
Yep.
I also understand that Mr. Doyle alleges that I committed a fraud in issuing guaranteed checks under the addendum. Although the checks were undated, meaning it was unclear if or when they would be presented, at the time of issuing them, I had no reason to believe they would not be honoured. D1 was still owed money under the addendum, the subcontract on the project, and therefore, if the claimant had acted in accordance with those agreements, the account should have been in funds. So, at that point, and that is that this appears to be accepted. D2 believed the checks would be honoured. The checks were undated. He had no way of knowing the dates on which the checks would be presented. And on the 24th of April, and that's H371, he had said, and you need to get, it's the second complete paragraph on that page, the paragraph beginning, BAM threatened Affan. Do you have that?
I will in a minute. It's in the middle of a long exhibit and it takes a while to get there.
I have a search key which seems to work quite well.
I'm sure it does.
I'm sorry, that wasn't meant to sound smug.
No, it was probably meant to sound efficient, and I'm sure it is. But anyway, I'm there now.
Good. The short point here, Your Honour, is that this is Affan saying BAM knows that Affan's accounts do not have sufficient funds, and the checks will bounce. Now, rather than BAM coming back saying, well,
We're 371. Just looking for the paragraph.
It's the paragraph beginning BAM threatened Affan. It's
yes.
the second complete paragraph. You got that?
Yeah.
Rather than BAM saying to Affan, well, tell us an account that does have sufficient funds in it, they simply go straight ahead and present the checks. And it goes further than that. Under the terms of the contract addendum, and I can take you to it if you like, but I don't think there's a dispute about it, it had been agreed that the security checks in any event would be returned when 500 panels had been delivered. At the date the checks were presented, 494 panels had been delivered. Now, we accept that we are still 6 short of the magic 500. But again, if one wants to look at considerations of good or bad faith, then one must look at the claimant as being equally culpable. Sorry, you were saying?
I'm not sure I buy that point. But just help me. What may be more profitable? Can we just look at the addendum? Where can I find that?
It is.
Had it earlier. I've lost it for the moment. I know it was some previous bundle, but let's find it here.
It is, and it is.
But it'll be here somewhere.
You'll find it at B1.
B.
Sorry, bundle B.
Oh. Okay, is it not in this bundle?
It's not in this bundle.
It's at G40.
Oh, very good, thank you.
Thank you. Yes, there it is. Thank you very much.
And it's paragraph C1 in that bundle.
Thank you.
You might be assisted by just looking briefly at that paragraph. It's at the bottom of page 3. And it's the last sentence, which says the contractor shall return both security checks upon the delivery of 500 completed panels. Now, we accept that the word both is misplaced. Actually, there are 4 of them in total. But the point of right, I think it's the same point.
Yeah. Anyway, you say you nearly got there.
We say we nearly got there, and as far as bad or good faith is concerned, we say it's a two-way street. But things get worse.
Yeah, just pause there, but I'm struggling with that. They're entitled to present the checks. They're entitled to present the checks. There's no bad faith there. I can understand your point, as far as it goes, that having got to 494 out of 500 may tell in favour of there not being bad faith when you issued the checks, because you almost made it.
Yes.
Not if there was 1 out of 500, it was 494. But it doesn't follow from that there's bad faith in presenting them if they're entitled to.
Well, I take your point, Your Honour. I'm not sure that you get to I think you get to the same end point, don't you? Albeit by different means.
Okay.
And just to complete the story, it is, I think, accepted by both parties that on the 2nd of July, the claimant then cashed the defendant's bonds. And the defendant, on that basis, has essentially liquidated a sum of approximately 21 million. Now, there's no dispute that they did that. The claimant says, and no doubt you'll be addressed on this. But what the defendant says is that the claimant has liquidated a sum significantly greater than the amounts of the security checks, and it has derived that benefit. So again, we say that the allegations of bad faith or fraud simply don't get off the ground in those circumstances. The second defendant's state of mind, which he's said in his witness statement, was that he believed the checks would be met. In any event, the claimant's position was entirely protected by virtue of the bonds. So on that basis, we say that there simply cannot be a claim in fraud. So far as the other parts of Articles 84 and 162 are concerned, we say similarly, those just don't get off the ground. And you can test this in this way. You can say, were the actions of the second defendant in any sense inconsistent with an officer of a company simply going about managing his business in the ordinary course of events.
Sorry
We
to
say,
interrupt you. I'm sorry.
yes,
Can you just take me back to Articles 84 and 162?
of course.
Just helpful to have them while we think about this.
Yes, it's pages I234 and 235.
Thank you very much indeed. Just let's get that. Okay. Okay, thank you. Let's have that. So let's go back now to your submission.
Yes, what we say is that the facts which the claimant relies upon simply do not bring D2 within these provisions, and we say you can test that by asking yourself, did any of this take D2 out of the realms of what somebody in the ordinary management of his company would do? We say absolutely not. And that would be an impossible conclusion to draw. And certainly, and we'll come on to the cases in a minute, it is nowhere near something which would justify piercing the corporate veil. We will come on to that in a second, but that would be my submission on this. I'd like then to turn to tortious interference. What you should start with is H595. And this is paragraph 35 of the claimant's skeleton. So I think I may have given you a bad reference. No, if you look at 8.1, this is our skeleton, and I've quoted paragraph 35 of the claimant's skeleton. I'll take you to the claimant's skeleton in a moment. Which is, you can start at page H15.
This is the double negative point.
This is indeed the double negative point. I don't think there's any dispute that the claimant said this. What the claimant doesn't do is actually tell you that there is a tort of tortious interference under UAE law. What it does, and it says that at H35. So I have just found the reference. And it relies on articles 282 and 283 of UAE Civil Transactions Code. And you'll find those at I33. Do you have those, Your Honour?
Getting there, it's articles
282 and 283.
Right, those in a minute. Yeah.
Very quick point. What these don't do is tell you that there is actually any such cause of action under UAE law as a tort of tortious interference, and we've been given no indication that there is, and all that we're told is there's no reason to think that the position isn't the same as it is in England. Well, with the best one in the world, that just won't do. And we can move on from there to the claimant's skeleton. We'll go back to H23, please.
Sorry, I'm a bit troubled that we're looking at different things. At I-33,
Yes.
I've got articles 282 and 283, but they are not the same as the articles 282 and 283 at paragraph 33 of Lord Marx's skeleton.
I think it's different translations. I'm sure he can clarify that point, but I'd rather take it that they were simply different translations.
Wow.
It is a difficulty with translating from Arabic into English.
I don't underestimate the difficulty, but those are very, very different. Anyway, perhaps Lord Marx in due course will explain where his comes from, but they just don't look the same at all.
Well, they do use very different words, and it may simply be a legacy of having been in this region for a long time. I have taken that the meanings are broadly analogous. However, it doesn't dilute my point, which is they certainly don't demonstrate a tort of tortious interference. Let's go back to H23 then, please.
Thank you.
And I've now been an hour, and I'm going to be about another 10, maybe 15 minutes.
As long as you finish by 11:30, my time, then we'll have a short break. And as long as Lord Marx is no longer than you, and you've then got a short time for a reply.
That's eminently sensible.
Okay, so where are we going now? You did say
we're going to H23, and it's paragraph 34 of his skeleton.
H23, yeah. Paragraph 34. Yeah, I've got his skeleton.
Yeah. For such a tortious claim to succeed, the claimant will need to prove D2's actions caused harm to the claimant, and the harm was caused by D2's improper handling of the claimant's contract with D1. Well, first of all, we say that based on what we have here, and you can then scroll down to H24 and paragraph 37. On the basis of the factual case mounted by the claimant and summarised in Mr. Doyle's witness statement, the elements of a claim in tortious interference, inducing or procuring a breach of contract compliant with the English law principles set out in the Kawasaki case, are plainly capable of being made out. Well, we say that's wrong at virtually every level. We're not concerned with the English law principles. We're concerned with a contract under the laws of the United Arab Emirates. As far as Mr. Doyle's witness statement is concerned, we've said, and we've set it out at some length in our skeleton, Mr. Doyle's statement really does not help you a great deal. And it is simply the case that you are given no assistance by this paragraph. Now, please go back then, paragraph 34. which is the requirement that D2's actions caused harm to the claimant. Now, I have already said that by virtue of the fact that the claimant cashed the defendant's bonds, it certainly hasn't suffered any harm. In fact, it's gained quite a considerable windfall. We simply don't know what the harm is supposed to be. The claimants have had the opportunity to set out their case in as much detail as they want, and this seems to be the best that they can manage. We're supposedly talking here about Canoon, the substantiation, and the security checks. Well, for the reasons that I've gone on about at some length, we say none of those get over the first hurdle, and quite clearly, the claimant has not suffered harm. It has, by contrast, incurred quite a considerable windfall, and we say that the claim in respect of tortious interference simply does not get off the ground. I'd like to take you now quickly to just a couple of the cases. I'm going to take this very, very briefly indeed. And I think I may come back to these depending on what Lord Marks says. But so far as the good faith points are concerned, I'm going to wait and see what Lord Marks has to say, because I've accepted that there is, under UAE law, a duty of good faith, and as such, I'm not sure how great the assistance that you'll get from looking at the English cases is going to be.
But I'll be very blunt about why I asked for it.
Yes.
My recollection, which may be wrong, is that the English cases draw a distinction between good faith and fraud.
They do, and let's.
That's why I was intrigued. Now, Lord Marks may be able to persuade me that recollection isn't soundly based, but I don't recollect, from looking at least one or two of them some time ago, that they equate the two.
Well, let's go in that case, without further ado, let's go to J249.
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 Can you say which case that is?
That's Mid-Essex. And what I wanted you to look at is paragraph 114, subparagraph 1, and the same point is made in paragraph 116.1. Now, it's not quite saying...
Are any of these cases reported in the law reports? I suspect they are.
I'm sure they are.
In which case, I'm sure that by tomorrow you can supply me with and put on the bundle the law report copies.
Absolutely, yes.
But always with cases, law report copies, please.
Absolutely. You'll appreciate, I'm sure, Your Honour, that this has been done in a bit of a hurry. So
a bit of a hurry, though. Perhaps they should have been done before there was a bit of a hurry. But there we are. 100, which paragraphs?
1141 and 1161. Now, this draws a distinction between dishonesty and mistaken applying the facts. But it's making it very clear that there is no finding of there is no finding of dishonesty on the part of the claimants in this case. The other cases I wanted to take you to quite quickly.
Yeah.
Are first of all IBM, which is this year, and that's at J197.
Yeah. Thank you.
And I just wanted to take you to paragraphs 32 and 33. This is the so-called principle in side and but, and this is quoting from the position in the slightly earlier case of Anthusis. This is the point. The point here is that, as it was described in Anthusis, if a servant acting within the course of his authority procures a breach of contract between the employer and a third party, he does not become liable in tort to the person whose contract has been broken. The liability, and this is set out in paragraph 33, and this is again quoting Mr. Justice Lane in Anthusis. The nature of the breach and its consequences may directly inform whether the officer of the company has breached his or her duties towards the company, that is to say, the company for whom he works. And the test, as it's set out in the Anthusis and the IBM case, is whether the director has committed a breach as against his company, as distinct from as against a third party. And the only other cases which I think in the time I need to take you to right now is Prest and Petrodel, and you'll find that at J79.
Yeah, I mean, seriously, if tomorrow you could make sure that we upload the law report of these judgments, it would be remarkably helpful.
We can certainly do that.
Thank you. Okay.
Might not be first thing tomorrow, but it will certainly be by the end of tomorrow.
I have no wish to get you up at an unearthly hour.
It's entirely your prerogative, Your Honour. So I
You do it at stage tomorrow when it's convenient.
thank you.
What paragraph would you like?
I would like you to go. I would just like you to go to paragraph 64.
Thank you.
And this is at page J110. There are other bits of this very interesting case which you may be taken to, but this is the one that I think really encapsulates.
And whose judgment is this?
Lord Neuberger.
Thank you.
Now, the authorities on this are fairly uniform, but this is probably the best. This is the best example that I've seen in looking at these cases. The courts are extremely reluctant to go to the lengths of piercing the corporate veil, and I mean, Lord Neuberger goes as far as to say there is not a single instance in this jurisdiction where the doctrine has been invoked properly and successfully. There is doubt as to whether the doctrine should exist. It is impossible to discern any coherent approach, applicable principles, or defined limitations to the doctrine. So I think this, and there are other examples I can take you to, but I don't think it particularly assists you. You are being told exercise this power with the very, very greatest of care. As I say, Your Honour, I can take you to one or two other cases which make the same points, but I'm not sure that you're going to be greatly assisted by them. And that being the case, unless you have any questions for me, that was what I wanted to say.
Mr. Cornell, thank you very much indeed. Right. Well, what I suggest we do, I say this to you both, my clock is showing 11:21. If we resume at my time 11:35, would that be convenient?
Very.
If I take the view that Lord Marks should then finish, he said an hour, but I won't hold him to that. Say by 1300 my time, gives him an hour and 25. And then, Mr. Cornell, a short reply, if you want one.
Yes, fine.
Does that sound roughly convenient, Lord Marks?
Your Honour, it does. I'm a little concerned at being restricted to 125. I'll need, in the arrangement that we made, we had provision for replies on both sides.
Oh, right.
I think I will only need a very, very short reply. If I could have an extra 10 minutes if I need it, I'll be grateful. I'll certainly go for 125 if I can.
My times are aspirational, but nobody's going to be shut out from adding a brief word in reply if they want to add it, bearing in mind the law of diminishing returns.
Yes.
Very good. Please have
Thank
a break. See you at 11:35. Thank you. Mr. Cornell, I'm here. You are here.
And I'm here.
And Lord Marks is here. Good. Lord Marks, at the moment you're a circle on my screen.
Ah. Perhaps I'll turn the camera off and turn it on again and see if that works.
I was going to say, I can see you. I don't know whether that's of any interest at all.
Has that helped?
Yes, it does. Thank you.
Good.
Over to you.
Yes. Thank you, Your Honour. What I proposed to do was just to start with a number of preliminary points arising out of Mr. Cornell's submissions. The first is a simple one. He was suggesting, and indeed he suggested in his last round of submissions, bar one, that we were abandoning the reliance on the nest case. And that is a fundamental misunderstanding. We developed the argument based on the nest case very thoroughly in our June skeleton, which is at page G161. I needn't ask you to turn it up. The relevant paragraphs are 18 to 33, which start at G165. And when we dealt with our application to amend in a further skeleton, which you directed that we should put in at page H15, we said at paragraph 2 in the introduction, this is the claimant's skeleton argument in support of its application to amend the claim form.
I'm so sorry, Lord Marks. Somebody's sharing the screen.
Yes, it's a case of pressed, and I don't know why.
No, I can't help feeling that it's sharing the screen is more trouble than it's worth.
Apologies
I
for that.
agree.
We'll remove the sharing option.
Thank you.
I
Well
think
intentioned, no doubt, but when we've got the bundle, which we're all working, probably as easy just to use the bundle.
I quite agree. I'd be much happier to deal with it on the documents I've got in front of me.
So you were June skeleton, paragraphs 18 to 33.
That's just my reference.
Yeah.
And the incorporation of those into our present case is at page 17 in paragraph 2 of the introduction.
Yes.
We say this skeleton argument should be read in conjunction with the claimant's skeleton argument dated the 8th of June, served in opposition to the challenge. And so we've never abandoned nest, and indeed when we come to it, and I will later a little bit shortly, the nest case contains the route to jurisdiction under the jurisdiction law that we say applies, judicial authority law. The second preliminary point is that Mr. Carnell, in his submissions, has suggested that there is a gap of considerable dimensions between us on the principles applicable to amendment. I don't see that. We accept entirely what is said in the Affan case, which is at I-432, on which he relies. That sets out the common ground that in order to add causes of action by amendment, the claimant has to show a good, arguable case. It mustn't be merely fanciful. It must have some conviction. The only difference that I discern between us is that the test on an amendment which adds a cause of action in fraud is the same for fraud as it is for any other case, whereas Mr. Carnell appeared to suggest that the standard or the threshold is higher in fraud cases. That is not so. However, we for our part accept that serious allegations are made. They need to be seriously made and pursued, and the amendment will only be allowed on the basis that those allegations are proper. And I accept, as I did in June, that involves showing how the case will be put. And although we didn't have to plead the case before the jurisdiction application was be determined, you rightly directed that we should set out extracts of a draft pleading setting out what is alleged, and we have done that. That, however, is not a full pleading and is not a finalized pleading. And Your Honour took the point that we hadn't actually alleged fraud. Mr. Carnell didn't adopt that because he pointed to Articles 84 and Article
I think I may have been wrong.
And I think that's correct, but I think it goes a little further than that. Because although we haven't specifically pleaded in deceit, which is a specifically English tort, I suspect, what we have done throughout in those extracts is pleaded the words fraudulently and dishonesty. And that is designed to play both into the Article 84, Article 162 points and into the breach of contract. And I'll attempt to develop that in these submissions, because it is our case that it is absolutely clear on analysis that there is strong evidence, a strongly arguable case, that Mr. Affan behaved fraudulently in his dealings with BAM, and that involved the breaches of contract, which we've relied upon, as well as the Article 184 and 162 cases. Another preliminary point is that what Mr. Carnell said is, well, you're only specifying fraud in relation to, I think he said 17% of the overall damages claimed. That doesn't matter. I'm not suggesting that the liability is coextensive. What I'm suggesting is that the second defendant, Mr. Affan, is a proper, necessary and proper party to proceedings which are properly constituted and brought against the company, the first defendant. The next...
It can't make any odds. If heavily underlined, there's a properly arguable case of fraud. The fact that it's 17%, 18.5%, or 29.2% doesn't make a jot of difference.
That's my point. You have to decide whether he's a necessary and proper party.
I mean, if it's wholly de minimis, that might matter.
Yes.
But if it's, as long as it's not de minimis, the fact that liability for fraud will be a notable but small percentage of any total claims, neither here nor there.
I respectfully adopt that. And I also say that in considering the question of whether Mr. Affan is a necessary and proper party to the case, his fraud is part of the overall picture. and therefore it avoids duplicatory litigation, which is one of the points Mr. Justice Cook had in mind, Lord Justice Cook had in mind when he dealt with this point. If I could deal fairly quickly with the English cases on piercing the corporate veil. I must say, I'm sorry we didn't provide, and they can, of course, be provided, the law report cases. I was always brought up to believe you should use the law report cases, but there's been a recent tendency to rely on the neutral citation reports, and I don't like it because you don't get head notes or anything else, and you don't get the argument, but we will rectify that and go back to the old-fashioned way.
Not too early tomorrow, Mr. Cornell.
Well, I think Mr. Carnell's going to do it, and he gets there first, as it were, to tomorrow. So yeah. Let's let him.
But I did say whatever time suited him tomorrow.
Yes. The two leading cases on piercing the corporate veil are undoubtedly VTB and Prest. That's clear from all the authorities and the learning on this now. They both date from a very short period in 2013. I've set out the paragraphs as a whole that I've invited you to read, and I'm working on the basis that you've done so. But if I could just read a couple of paragraphs.
Because I received the cases this morning, not that long before the hearing. So please don't assume I've had a chance to read them yet.
I certainly won't assume you've had a chance to read them, but I will remind you of what the paragraphs we rely on are.
Thank you.
And I'll highlight some points in very few of them. Yes. So in VTB Capital and Nutritech, it's paragraphs 118 to 148.
Yes, I received a rather humorous comment that although you'd put in 6 instead of 3, as there were only a few paragraphs, I probably wouldn't mind.
Yeah, that wasn't mine.
Followed by at least 30 paragraphs from the very first authority. So whoever put that forward, I salute.
Yes. That was Mr. Blakeway, who is extraordinarily droll in that respect.
Well, can I say to Mr. Blakeway, I appreciated that. If 6 instead of 3. Right, where are we? We're looking at.
So I was just going to take you to really to point to the principle which is set out in 127, which is that although there is an argument that there shouldn't be a piercing the veil possibility, that should not prevail. And then I wanted to take you to 143. And 143 is important in one way because it highlights the difference between England and other jurisdictions, which is dealt with in the next 3 paragraphs. So abusing the corporate structure is not of itself enough in England. Otherwise, it seems to me an illegitimate extension of the circumstance in which the veil can be pierced, he says. And then at 144, it's true that in many civil law systems, abuse of rights is a well-recognized concept. May be appropriate for a domestic court to apply such a principle in relation to some areas of EU law, probably not now. However, it was not suggested to us that it should be applied as a new or separate ground in domestic law for treating Mr. Malafeff as contractually liable to VTB, or that it would assist VTB in this case. And that at 146, the proposed extension is all the more difficult to justify, given that it's not needed to enable VTB to seek redress from Mr. Malafeff. It's clear that if VTB establishes it was induced to enter into the agreements by the fraudulent statements he's alleged to have made, Mr. Malafeff will be liable to compensate VTB. and he's referring there to an action in deceit. And so there is a principle in English law, and we come to it also in the press.
Excuse me, very sorry to interrupt. It seems like our learned friends have dropped off the call, so I don't know if you want to pause a moment to give them time to reconnect.
Thank you
Yes,
very
of course.
much. Yes, I'd certainly.
Apologies for that interruption.
No, not at all. That's very helpful. Thank you. Lord Marks will hold on till Mr. Carnell at least is back.
By all means.
Thank you. Now, from a circle on my screen, I think we may have Mr. Carnell back.
You do, and I had fallen off just when Lord Marks was referring to paragraph 143.
Okay, well, let's go back there. He'd taken us to 127, then 143, and we did move to 147, but if Lord Marks would go back to 143, then we'll make sure that nothing was lost.
Yes, I'll happily do that. So in 143, there is a proposition, maybe a little less than a proposition, but the question is raised as to whether abusing the corporate structure is ever enough to justify piercing the corporate veil. And that's not done in this case. And I was making the point that that is, or maybe true of English law, but it's not, as I will attempt to demonstrate, true of other systems of law. Then I pointed to 144 as well, which deals with abuse of rights in other civil law systems as a well-recognized concept. And I'll develop that a little further. And then at 146, rather than 147, I was pointing that in English law, and this is an example of this, it was difficult to justify an extension of piercing the corporate veil in a case where the claimant would have other redress by means of an action for deceit, so that piercing the corporate veil was not necessary. And that's dealt with in 146. And then 147, as Mr. Carnell rose, is the one that effectively overrules the Gramsci case. The other leading case is the case of Press, to which Mr. Carnell has referred. And the main paragraphs in Prester and Lord Sumption's paragraph 16 to 35 in his judgment. And I draw particular attention to the way the principle is put at paragraphs 27 to 28. And then in Lord Neuberger's speech, and this is a longer paragraph, a longer section, 59 to 83. And I draw particular attention to 59, I wished, however, to add a little to what Lord Sumption says on the question of whether, and if so, in what circumstances, the court has power to pierce the corporate veil in the absence of specific statutory authority to do so. And we say that there is specific statutory authority in the UAE to pierce the corporate veil, which is to be found in Articles 84 and 162. Also of significance in this speech is the passage from paragraph 75 to 77, possibly including 78, which makes it clear that there has been a great deal of judicial comment on the lack of coherent principle in the application of the doctrine. It deals with a number of comments in other common law jurisdictions in New South Wales, Canada, New Zealand, South Africa, and then deals with judges in the United States who've been critical, even though the doctrine has been invoked and developed to a much greater extent than in this jurisdiction. And such limited research as I've done on the United States position is that it is absolutely clear that while the doctrine is invoked in different ways in different states and applies differently in different states, nevertheless, the corporate veil is much more regularly pierced in the US than it is in England. And then at 77 is a question about the doctrine as seen by academics, and that's answered. My point is that although these authorities established that it is quite difficult to pierce the corporate veil in an English context, and I accept that, nevertheless, the capacity to do that is established by the two leading Supreme Court authorities, and that it is not the same in the UAE. And I say that it is common ground between us on the skeletons that have been put in, that fraud is an exception to the principle that a director of a company and the company itself have separate legal personalities, so that the director is not liable for the company's actions or breach of contract. And if I can take you to page H18, which was the page after the page we were looking at in my skeleton, I set out that application of the principle, support for that assertion that this was common ground. Paragraph 9, that's a principle accepted by the defendants in their statements of case in connection with the jurisdictional challenge, as listed in my skeleton argument for the June hearing. They said the second defendant's legal obligations are owed solely to the first defendant, save in the case of fraud. 39C, Article 84 states that a manager shall be held liable vis-a-vis third parties for any fraudulent acts. And 310, in its judgment, this was the Dubai Court of Cassation judgment, which we'll come to, matter 393411 of 2021, the court confirmed that if a manager concludes a transaction with others in its name for its account and within the limits of its activity, the company is bound by the effects of this. The exception to this is if fraud is proven and evidence must be established accordingly. And so we say that the defendants have in the past accepted that in cases of fraud, the court in the UAE is entitled to pierce the corporate veil. And if I can take you to that decision of the Court of Cassation, I don't know, I always say Cassation with a French accent, but I don't know whether that's right in a Dubai context. But that decision is at I-397.
I don't, just pausing there, I didn't detect Mr. Carnell to say that you couldn't pierce the veil, if that's the right summary of the concept, in the case of fraud. I think what he said is that there wasn't an arguable case of fraud.
I may be wrong, but I think that does him an injustice. I think he was relying on the English cases as establishing that piercing the corporate veil wasn't possible even in the case of fraud. I may be wrong, but I say it certainly is possible. He certainly argued the second limb, and I'll come to the facts and address that in the major part of my submissions to show that we say there's a strong arguable case of fraud in this case. But to make good my submission, which is, as a matter of law, I suspect important, that fraud is an exception and gives, and importantly, the second limb, which I think he did dispute, gives rise to liability for breach of contract. And it may be that he said, yes, you can establish fraud under Article 84 and 162, but I took him to be arguing that doesn't make a director liable for fraud in the for breach of contract because fraudulent. The case that I referred to is a very recent case. It was the judgment of 31st of January this year. Case started in 2021. The judgment starts at I-397, and the important passage starts at 422. And it's probably sufficient to start at the top of 4.2. Yes, at 422, I think. It is established, so it says, as it is, whereas this contest is groundless, as it is established according to the judgments of this court. Do you have the passage?
Yes.
It's off the page. That the manager of the limited liability company is the one who manages the company, and that if he carries out a disposition with third parties in its name and for its account, and within the limits of its activity, and we say carries out a disposition with third parties must mean enters into a contractual arrangement. The company is solely bound by the effects of this disposition. It is also sustained that the manager of the limited liability company shall not be liable in terms of his own funds, except in the event that fraud or clearly apparent deceit is sustained, or in the case of violation of the law of the company's articles of association and his management. Fraud and clearly apparent deceit are not presumed, it must rather be alleged and evidence must be sustained. It is also established that the contract is originally or directly concluded and may be concluded by authorization, unless the law requires otherwise. If the representative concludes a contract in the name of the principal, the provisions, terms, and contracts of this conditions of this contract and the rights and obligations arising therefrom shall be added to the principal. The ruling agency is the transfer of its effects in terms of rights and obligations for the principal. The agent contracts the third party in the name of the principal and for his account, then the effects of the contract and the rights and obligations arising therefrom do not affect him, but rather affect the principal in light of the above. Judgment of first instance endorsed by the challenged government has grounded its ruling in this regard by not accepting the case against the second and third respondent according to the reasons stated therein, that the second defendant had acted as a representative and deputy of the first defendant company. If it was not proven that he committed a personal mistake or acts of fraud. Therefore, the effects of the contract do not affect him, but rather affect the company solely. Thus, the pleading is legally and factually grounded. So it's quite clear from that that what is referred to here is that liability for breach of contract is generally the liability of the principal, but that is not the case where fraud is established on the part of the agent who is the manager or the director of the company. And that is why I say that the law about piercing the corporate veil is quite clear in the UAE. And this was a fairly lengthy reasoned judgment, and nobody suggested that it's wrong. Indeed, it was the defendant who relied on it at the outset. And if we establish the fraudulent behavior of Mr. Affan, we say that this clearly applies and he is personally liable for that fraudulent breach of contract. Now, breach of contract is already in the pleading, although it needs tidying up because it was only in the remedy, in the claim form. And we apply to add it to the to the particulars of the claim. So the first point, therefore, is that covers breach of contract that is tainted by fraud. The second point is that Article 84 and Article 162 are specific statutory provision as referred to by Lord Neuberger in press to paragraph 59.
Why does it matter if you can show fraud to the sufficient standard to justify an amendment? Then you home and dry for pleading purposes under Articles 84 and 162.
Yes.
And I had better be careful, but I didn't think that was an issue. But even if it is, Mr. Carnell's on the ropes on that. Why does breach of contract then matter?
I submit that it doesn't.
No.
Because I submit that the necessary and proper party test
Yes.
can be satisfied by my establishing a strong, a good arguable case on fraud under Article 84 and Article 162.
Yeah.
I understood that certainly at the beginning of Mr. Carnell's submissions, he was arguing that if I don't get home on contract, I don't get first base. I don't understand that submission because the jurisdiction under Nest.
You've got a jurisdictional problem under 5A2. Though one can probably get over that if one had to. But the difficulty you've got is there isn't a written agreement.
Well, that's what he said.
Yeah,
and that's not true.
But hang on, it doesn't matter, because if you've got a sufficiently arguable case of fraud,
yes,
to get you in under 84 and 162, if you've got that, then as far as I can see, with respect to Mr. Carnell and any subsequent submissions he may make, you're obviously on strong ground in saying you're at least a proper party, whether or not you're a necessary party.
Yes.
And that's the Nest case.
Yes, I say necessary and proper under Nest, but the route is through the written agreement with the first defendant, which is contained in the addendum, which hasn't been challenged.
No, D1, you've got jurisdiction against D1.
Yes.
If that's in dispute, it's indisputable. So there's not a problem for you on that.
Yes.
So we start with that. Thereafter, if, always underlined, you have a sufficiently arguable fraud claim, then you've got a potential case against the second defendant, as I call him, under 84 and 162.
Yes.
So far, so good from your point of view. Then you need to establish jurisdiction. If you've got that far, it's difficult to say that he's not a necessary and proper party.
Yes.
And you don't need 5A2.
No. Well,
which is a more difficult argument.
Your Honour, I'm not.
Isn't it?
I only need 5A2 in respect of D1. And yes, as you rightly say, I've got it. Well, therefore, necessary and proper party to proceedings already properly constituted against D1. That's the route.
Yes, you can't get D2 in under 5A2.
No.
And that was the point Mr. Carnell was making with force earlier. At least that's as I understood it. But yes. I don't think, I may be wrong, but 5A as to D1, there's no serious argument to the contrary with respect.
I agree. I thought the problem that I had was that he was saying I no longer relied on Nest, and Nest is my root to jurisdiction.
He did say that, but that was an adventurous submission.
Yes. Well, it seems to me that the right way to deal with this now is to go to why we say the fraud case is so strong.
Well, I suspect that's probably what we're really arguing about.
Yes. And if I may please take you to, this will involve looking at a number of documents. I'll deal first because partly because Mr. Carnell did and partly because it's probably the more detailed assessment.
So what are we doing?
Historical costs claim.
We're looking at fraud the facts.
Fraud
that-
the facts.
Okay.
And I'm going to deal first with the historical costs claim. And putting it briefly, what Mr. Carnell has addressed, and indeed what Mr. Affan has addressed, is an allegation that completely misses the point. He is suggesting that all this is about is a complaint that Mr. Affan masterminded spending money that was received in respect of historical costs by spending it otherwise than on meeting obligations. That is not the false claim that is alleged. The false claim that is alleged is a claim in respect of historical costs, that is, costs that had already been incurred, by a representation that was absolutely clear on the documents that Canaan, the ones we're picking on, had already been paid this money, and that this was a reimbursement claim that was and could be properly substantiated. And that was not true. So when Mr. Affan says, as he does say, and it's probably as well to look at it briefly, it's very short, in his second statement, at page H617, and it's worth reading the whole of 1.1, we say that's all misplaced. He says, I understand that Mr. Doyle has accused me of misdirecting funds paid by the claimant to D1 to cover historical costs. This is denied. I confirm the claimant made 2 payments to D1 covering historical costs on 17 December 2018, 7 million, 20 January 2019, 4 million. At the time of making the payment, the claimant did not indicate which historical costs had been accepted. And I'll show you that's not true. They did not tell D1 that it should hold on to the money until further instruction. That's irrelevant because the representation was this was a reimbursement claim. On that basis, the company prioritized payments based on which costs needed to be paid first in order to keep the project operating. That doesn't address what's alleged against Mr. Affan at all. In the absence of instructions from the claimant, this was appropriate for the interests of the project, and under the terms of the addendum, I believed a further amount of AED 4 million was to be paid. That on analysis doesn't turn out to be right, as well he knew what was going to be paid when he received the money on the 20th of January. I believe that a further amount of AED 4 million was to be paid. However, the claimant only ever made one more payment in respect of historical costs, which was 1.5 million, less than expected. 5th of February 2019, the claimant then provided a list of historical costs which it would accept even on an interim basis. To me, this was unexpected as monies had already been distributed and a shortfall remained, which the claimant still failed to pay. That now needs to be compared with the reality of the documents. And we say that the claim itself was dishonest because it was dressed up to demonstrate that the monies had been paid when they'd not been paid at all. So if I can start, please, with the documents at H158, which is the letter of the 26th of November, which is referred to by Mr. Doyle at paragraph 58 of his witness statement. And it's important to remember these are historical costs, and that is the rubric under which they're claimed. And further to our previous letters, and as requested at the meeting held in the AIS office on the 25th of November, related to the substantiation of 15 million requested on account for the project costs incurred, kindly find the breakdown of the same as follows. And at little 9 down there, we'll see Canaan labor outsourced. At that stage, he's claiming 2.339 million AED. And then at the end, we're unable to sustain such an increase in the project cost without your continued support and would request you to release the requested amount at the earliest. And if I can take you, please, to H54. Paragraph 58. It's probably worth going back because it'll save me going to another document. To 56, please. I'm sorry, on page H53. BAM was proactive in its efforts to demonstrate the level of substantiation that was required. This is after the statement that the costs had to be legitimately substantiated under the agreement. For example, on 6 January 2019, shortly after the signing of the addendum, I personally chaired a meeting with Mr. Affan to explain the level of substantiation required to support all payments to be made by BAM under the addendum. This was summarized in a document I prepared, which I emailed to D2 following our meeting, and is then screenshotted into page H54. And if you look at clause C1, which deals with historical costs, what was required, subject to proof and substantiation, was salaries and so forth. And every single one of these requires proof of payment. And most of them require invoices as well. And certainly labor requires proof of payment. External labor, approved timetables, invoices, proof of payment. Everything requires proof of payment. And so at 58, Mr. Doyle is absolutely right to say the historical costs under clause C1 of the addendum were derived from D2's letter to BAM dated 26 November 2018, requested the payment of 15 million. The fact that these amounts were for costs already incurred meant that they should have been quantifiable from the outset. The addendum was signed on the 17th of December, so after the 26th of November letter. And the document that I've shown you from the screenshot is also H304, and that follows the 6th of January meeting.
So does it come to this? You say that the Canoon amount claimed as having been paid had not been paid.
Yes, and it's common ground that it wasn't paid. Only 200,000 was ever paid to Canoon. Canoon eventually had to sue the defendants, and they won for that money.
Yes. So it's as simple as that. He said to you, we've paid Canoon, hence we're claiming reimbursement.
Yes,
When
but it goes much further than that. I mean, when I say it doesn't go further than that, but the documents go further to proving it than that.
Okay, I'm just
So
trying
you can go to H320.
Yeah, I'm not cutting you short. I'm just trying to understand here.
No, that's your summary is absolutely right.
Okay.
At H320, the 8th of January, so 2 days after this meeting.
Hang on. H320.
Yes.
This
is an email from Affan Thanuja, the commercial manager. The meeting was, of course, with Mr. Affan himself.
I'm sorry, could you repeat that page number?
It's H for Hotel 320.
Thank you.
And it's headed Substantiation Summary for the 8 million expected on 15 Jan 2019. And this is 8 million odd that is expected. And the items are numbered 1 to 12, and number 5 is Canon Labour outsourced 1860 April to July invoices. So that's stated there, April to July invoices, and that therefore refers to April to July 2018. So the last invoice that's claimed is 6 months before the date of this email. And that is added in to the claim by the defendant. And this is expected in connection with an £8 million dirham check expected on the 15th of January. We see that from the heading. And we see in the introduction, with reference to the addendum to the subcontract clause C1, which is the clause, the substantiation of which we looked at, kindly find below the summary for the payment of 8 million expected to be released by 15 January 2019.
Now, this is a fairly sizable contract. Yes. Is it said, well, it may have been an error, but incompetence or laxity not quite the same as dishonesty?
No, that's not said. What is said is I've been accused of misapplying funds at a later date.
That's a different,
which I didn't know.
Yeah.
And I didn't know what I was to do with the funds. And going through these documents, I aim to demonstrate that that wasn't what was being done at all. What was being done was a claim for disbursements already made.
That's why I say your case. I'm not expressing a view.
Yes.
Either side's case. Your case is very straightforward. There's a claim that I paid Canoon X, but I haven't paid Canoon.
Yes.
And that's it, really.
Yes. And substantiation has to include proof of payment. He's expecting 8 million. He adds up items 1 to 12, and they come to 8 million, having rejigged Canoon to 1860. And he says that's the April to July invoices.
But there are none.
Well, we haven't had the substantiation. And he says that the next point I make is that he says the supporting documents for the above will be ready for collection within this week from our office in a folder as the size of the file is large. And then also as requested to Mr. Dermot, we expect to receive the original of the signed addendum within a couple of days.
Okay.
And the defense to this is not, we made a mistake. The defense to this is at H607 to 608. And it's all about at 6.3, if you look at the bottom of 6.3 on internal page 6, H607. It's this story about the funds being distributed when they arrived to keep the project moving, and they didn't know what the funds were paid for. And that simply, as we'll see, doesn't fit with the facts at all. 6.3 is, in spite of the rhetoric about our case being nonsensical, just makes no sense at all and doesn't address the case. And the next document I'll take you to, if I may please, is at 308. A letter again from Affan's commercial manager. Pursuant to the subcontract addendum calls C1, we understand the payment of 8 million is expected to be released by the 15th of January. This is the 10th of January. Based on the same, we record that all the sufficient supporting documents relating to the post was emailed you today. Security check of 8 million is ready with us. And if there's any further clarification is required, do let us know. Now they know that supporting documentation has to include invoices and proof of payment. And then on the 17th of January, Mr. Dermot comes back at H307 and says, I spent all afternoon yesterday going through the documentation you provided based on the requirements explained to you in our meeting of 6th January. Reference back to the document at H54. As explained, if there's a substantial amount of information that's not been provided or is insufficient, I note you've not provided any information in relation to the initial 7 million payment BAM made last December. I enclose a summary of our review of the documentation you provided, which highlights what we can accept in principle, subject to receipt of the additional information, and the items whereby no information has been provided. I suggest you address these deficiencies as soon as possible so we can get to a position whereby Affan has provided the required substantiation to enable BAM to make a further payment. And if you go from there to H309,
Yeah.
that's the document he's talking about. And so what they say is that if you look at item 10, that's in the column item noted in the 26th November letter. Next column, item noted in a Affan email 18th of January, which we've looked at. Sorry, 8th of January. It's reduced to 1860. Amounted noted in Affan submission 17th of January. That's the 1860. And that's really the that's this submission. And then accepted in principle, but subject to additional substantiation. This is the comment on it. 1860-732, signed, stamped, approved timesheets, cards, clock in and out. That was additional substantiation required, and it's not provided. And it's quite clear that the implication is, not the implication, the assertion is that that's been paid. And what then happens is that at 3:06 on the 20th of January, H306, Mr. Doyle softens his position slightly. We've finished reconciling the file you handed over to me on the evening of 17th January. Note much of the requested substantiation has still not been provided. Again, refer to our meeting of 6th January where we explained in detail the exact substantiation required. Notwithstanding the above and in continued demonstration of BAM's goodwill towards Affan in the interest of the project, we've made a more than reasonable assessment of the provided substantiation, which we indicate on the attached spreadsheet. Based on the documents that have been provided, we can accept in principle a sum of 11 million, of which 7 million has already been paid. Please note that BAM still requires all outstanding substantiation in order to close this particular exercise. Upon receipt of the confirmation to the above, we'll provide a check for 4 million, which can be released to you upon receipt of our security check. Finally, BAM doesn't accept any responsibility for the delay. And then what happened was that at H305, you'll see the explanation of how this document is repeated. So on 21st of January, a PDF of the historical cost summary of the review appears at H578. And that was attached also to the payment certificate. And we see in Mr. Doyle's statement of paragraph he deals with the history I've outlined to you at 60 to 65 on page 55. And then at 66, he says, in the months that followed, D1 and D2 failed to provide BAM with the required substantiation, despite repeated reminders from BAM. And then he explains what happened about Kanoon in 67 to 68. Kanoon labour outsource was one of the items originally listed in Second Defence letter of 26 November, as we've seen, requesting payment of 15 million from BAM on account of the project costs incurred. Some claimed it was 2.39, reduced, confirms it was intended to cover April to July invoices. And then at 69, paid the 1860. Subsequently, in or around June 2019, approached directly by Kanoon, and they say they learned that only 200,000 had been paid. That was raised on the 10th of June 2019, paragraph 71. Included under the payments made by BAM towards the historical costs was the sum of AD 1860,732 in relation to amounts owed by Affan to Kanoon Marine. BAM paid the sum to Affan in good faith of Affan paying the full amount to Kanoon. However, it's been brought to our attention that Affan's not paid this amount to Kanoon, in fact, only paid a sum of 200,000. This therefore means that Kanoon's kept the remaining amount of 1660,732, referred to attached summary of historical costs paid by BAM and statement of account provided by Kanoon. Shown below is a copy of Kanoon's statement of account dated 24th of February. BAM emailed in its email to D2, only 200,000 paid over the period, and that's Kanoon's account. And BAM never received a response to this letter. That's at paragraph 74.
At paragraph 76,
Yes.
there's a complaint about the dirhams 12 million plus. Kanoon,
Yes.
in fact, a much smaller amount than that.
The 12.539,
Yeah.
Kanoon's a much smaller amount. Kanoon's just a sample that we've got.
1.6 million or whatever.
Yes.
But what's the claim about? Is it the whole of that, or is it the 1.6?
Well, the fraud at the moment that we can substantiate is Kanoon.
Okay.
And so I haven't pleaded anything, or I haven't set out
No.
anything further in pleading.
I'm just thinking that if no conclusions today, if you got permission to amend in respect of this aspect of your claim, be limited to Kanoon.
At the moment, it will be limited to Kanoon. It is possible that following disclosure, we might be able to add other allegations.
For another.
That will be a separate matter and for the future. But the 12.539, to explain it, is the 7, the 4, and then there was a subsequent payment of 1.539.
It's what you paid, yes.
Yes, and that's what we paid, and that is all secured by the security checks, which is another another point. So that's really the next point I want to deal with.
Okay, so we're moving to security checks, or the other. There's a point.
There was one last point I wanted to make was the assertion. It may be that this has come across in my submissions already. The assertion that Mr. Affan did not know what was being paid in relation to Kanoon or what was being paid as part of the 8 million is belied by the email of the 8th of January at page 320, which makes it clear that they knew that the 8 million was 8023, which included 1860 for Kanoon. So that they knew exactly what was being paid.
Yep.
And they knew exactly the basis upon which Affan thought they were paying it, which was that it had already been paid.
Okay, so that's historical. Now,
Yes, so the second point, the security checks.
there was, sorry to interrupt, between historical costs and security checks, you had another point in your
well, I've
skeleton.
got a third, yes. I'm not sure
What
which
was that?
order I dealt with then. There is the payments that are unrelated to the project, to the Museum of the Future project. So there's a complicated, I'll come to it, but there's a complicated or a convoluted explanation put forward by Mr. Affan that he was claiming in respect, and he thought well, he doesn't say so, but he implies that he thought he was entitled to put goods that were bought for other projects or to use on Ministry of the Future and claim for them, and that's what he'd done. That's the implication, even though they were bought for other projects. And he's basically saying the goods he was buying were not project specific, in spite of the fact that if you look back at
But hang on, I don't know how much this is worth, and if you are pursuing it, if he bought goods for other projects and used them on this one, then there wouldn't be a problem.
well, if he had, but what we say is he was buying them for other projects, and at least half the substantiation on the clause C2 costs was for other projects, and that's what his commercial manager admitted.
So you mean he's charging you on your case for expenses incurred on other projects?
Exactly.
So, okay, I'm just trying to get a simple understanding. May I make a note of that? Just one
yes.
second. Okay, can we just dispose of this and then turn to the checks?
Okay, certainly. So the allegation is made in the particulars of claim, draft particulars of claim. If I can just show you actually at H54, a document we've looked at.
Yeah.
At the top of the page, all costs are subject to proof that they relate to the Museum of the Future subcontract works.
Yeah.
And that applies to clause C2 works, which are the letter of credit payments, in respect of which this 30 million AED is with which that's concerned. If I can go to paragraphs 26 to 28 of the draft particulars.
Yeah, 1 second.
Page H33.
So you're aggrieved at being charged for things which had nothing to do with your contract?
Yes.
Yes.
That's the fraud alleged.
What's the answer to that?
Well, what he says is, well, I may have bought them for other projects, but I had used some of the goods bought for other projects on this project, so I was entitled to spend for other projects. And I can show you where. Have you read 26 to 28?
Yeah. Yes.
So if you go to the defense, it's paragraph 6.6.
Is what he's saying, I bought lots of widgets. In the event, I used some of them for other projects. I used some of the widgets bought for other projects for this one, and then used some of the widgets for this one on other projects, and it all comes out in the wash.
That is what he's saying was allowed. It runs in the face of what we've been told by his commercial manager as pleaded in paragraph 28.
Yes.
Hearsay, so we're not
And
sure.
that is a prima facie case that needs answering. It also flies in the face of the obligation to provide substantiation and the clear position taken that substantiation must establish that all the expenses in respect of which a claim was made must relate to this project.
Yeah. Well,
So that's a specific bar on shuffling, if I can put it that way.
Yeah.
It goes further than that, because if he'd wanted to shuffle, he would have told us. And if he'd wanted to shuffle, he wouldn't have dressed up invoices as, in respect of which there was a requirement, as invoices connected with this project, when in fact they'd been spent on other projects. It would have been other projects. It would have been perfectly easy to explain that he was in fact using for this project items bought for other projects because he'd already used the items bought for this project and so forth. In other words, shuffling may be a little complex, but it is explicable. And where you're shuffling in a clear breach of contract, because the contract requires a particular type of substantiation which is agreed, and you're dressing it up as substantiation of goods bought for this project, that requires an explanation. And where your senior staff then accept and admit to you that a very high proportion of the goods purchased for or charged against this project were actually used for other projects without any mention of shuffling, that is a prima facie case that requires an answer.
How much is this part of your case worth?
Well, the claim in respect of it is 30 million AED, and half of it is said to be misplaced, in other words, misused.
So
it sounds like 15 million AED.
that sounded to me
Until
like,
disclosure, it's very difficult to.
that sounded like roughly 15 million.
Yes.
So it's not de minimis.
It's not, certainly not de minimis. This is a serious, if this is established and the judge accepts this at trial, it's a serious and a fraudulent use of the procedure for claiming advance payments, which under the original contract, of course,
And the basis for the fraud allegation is what you are able to put into your draft pleading from the commercial manager of D1.
Yes, it goes a little further than that.
Well, you say
because he's
the documents and the manner, the modus operandi and so on.
Yes, and the fact that there was the claim for all this money, and there was no substantiation of the use of it, even though that substantiation was specifically required and agreed. And it goes further than that, because they were saying that they'd provided the substantiation. Then they were saying they couldn't provide the substantiation, and they avoided providing substantiation that demonstrated it. And it wasn't until we got to the point of making this allegation that we then get the defense setting up what we say is a completely bogus explanation that chimes in with the explanation about the misuse of money rather than the historical costs allegation, where they answer the wrong allegation altogether.
And you say that on both historical costs and whatever we call this, unrelated payments, you say you've got enough of an argument to justify an amendment.
Yes.
Okay.
And I say that the evidence we have, plainly in cases of fraud, it's often difficult to establish every fact. The evidence we have is enough to raise a strong prima facie case, clearly arguable prima facie case. If made out, it would establish the fraud. It requires an answer, and we go further and say that Mr. Affan has not attempted to answer it.
Yep.
What he's done, I mean, in one sense, he's attempted to answer it in relation to this, but in such a convoluted way and without providing any documents that it's simply not credible.
Yep. Okay. Security checks.
The security checks, I mean, the broad facts are we say that they were plainly handed over, and this doesn't seem to be in dispute, to guarantee repayment of the sums advanced because they were all recoverable, and that is common ground. That is on the basis of a representation that they were good and valuable security and that they would be met on presentation. We say that is a submission which is fortified by the fact that passing checks that would be dishonored was criminal behavior in Dubai. That is the relevance of the criminal aspect of the submission made from time to time by Mr. Carnell and his team that we were trying somehow to get criminal jurisdiction, and the DIFC court has no criminal jurisdiction, and that therefore the allegations in relation to the checks were inadmissible, is not the point. The relevance of the criminal conduct is that it adds to the dishonesty, and it also strengthens the representation because the representation is backed up by the sanction for bouncing checks. Now, I quite take the point that the time at which the dishonesty has to be proved is the time of the writing out of the checks. But what we haven't had anywhere is an assertion by Mr. Affan that the checks were genuinely expected to be honoured when they were passed in December, January and February.
Well, hang on a minute. In his second statement, I think it's paragraph 1.4, but I might be wrong on my numbering.
No, you're quite right.
He says clearly, at the time I issued them, I thought they were good.
Well, he doesn't actually.
Hang on.
He says,
Okay.
I had no reason to believe that they would not be honoured.
Well,
but then he goes on.
Hang on, let me find it.
It's H618.
Yes.
And what he proceeds to say is on analysis nonsense.
Hang on.
Because he says...
Just let me reread it before I take on board your submission. Yeah, thank you.
So the difficulty with this assertion is, first, he doesn't say, I had reason to believe that they would be honoured, and this is the reason, here's my bank account. He's produced a bank statement in another context, to which I'll come, but he hasn't said that he believed they would be honoured. Nor has he said that circumstances ever changed, though Mr. Carnell's most recent submission suggests that that's what the evidence is. What he said is the first defendant was still owed money under the addendum and the subcontract on this project. And therefore, if the claimant had acted in accordance with those agreements, the account should have been in funds. That completely ignores the fundamentals of what these checks were about. These checks were guarantee checks to carry out a contractual obligation to which the first defendant had been bound on the basis of their being tendered by the second defendant as security for the honouring of its obligations. So these checks would only ever stand to be presented if the first defendant was in default of its obligations. And if the first defendant was in default of its obligations, there would have been no way that the claimant would have been continuing to pay it money under the subcontract or the addendum, because the claimant was entitled to recover money from the first defendant. So that the argument here, which is that he was relying on the continued receipt of money from the party to whom he was already obligated, and in circumstances where he was already in default of those obligations, which was the very reason why the security checks would be presented, is circularity with a hole in it, if I could use a horrible metaphor. It just doesn't work. In order to show that he expected the money to be paid, he can't be relying on the very money that he's not going to be paid.
Yes.
And we couple that with the fact that he's presenting, the checks are presented in June, but that date goes back to the 24th of April when he's writing the letter that we saw earlier, saying that there's no money in the account, so they'll bounce back. So what's the point in you presenting them? Or that's an unwarranted threat. When the last of these checks was given on the 10th of February, 2 months before, these aren't for insignificant sums. 20th of January was 4 million, 17th of December was 7 million. Each of them paid on the basis of that they were guarantees of repayment. And he has never said, I expected that they would be honoured, or I had the funds, or this is what happened, or there's a change of circumstances. And if I may say so without being accused of making a jury point, that may be why Mr. Carnell, in his submissions, and I don't suggest for a moment he didn't mean what he said, paragraph 5.1 at H736 says, when the claimant indicated it was seeking to present the checks, the second defendant informed them that circumstances had changed and the account did not hold the relevant funds. The claimant simply dismisses this as reckless, that's just flippant and unmeritorious. But he didn't say the circumstances have changed. What he said in the 24th of April letter was the claimant knows because I've told the claimant that the money isn't in the account and the checks will bounce back. We have no date for when that was apparently said, but nothing about any circumstances changing. And as one of the authorities relied upon by my learned friend set out clearly, although the relevant time for the dishonesty to be tested is the time at which the checks were written out and handed over, nevertheless, the fact that they're bounced is evidence of the act revealing the crime, and that's the decisions on a felony at page I378.
Hang on. I378. Let me get there. So which passage do you
So-
want?
Where it says rules text.
Yeah.
The felony of issuing a check without balance constitutes by the mere issuing of the check to the beneficiary without knowing, while knowing there is no payable and drawable balance on the due date. The presentation of the check to the bank on maturity has no bearing on the availability of the criminal elements, as it's a material act aimed at fulfilling the value of the check. And the bank's advice on the lack of balance is an act revealing the crime. Put another way, what that means is that is evidence of criminality, but it doesn't without more prove criminality. What it does do is raise a prima facie case of criminality so that it needs an answer. And we say that this plainly needs an answer, and it hasn't had one. And that is even more the case where Mr. Affan has put in a defense that really doesn't deal with this. So that his answer to the checks is at page H609. And it's all about taking issue with what has to be proved and what Mr. Affan is saying has not been proved. But it doesn't put forward anywhere a case to say that Mr. Affan's issuing the checks was honest, and he honestly believed that they were going to be honored. Indeed, he uses an argument at 615 that Mr. Carnell developed in his submissions, saying that we, the claimant, ought to have requested the first defendant to issue fresh checks on the receipt of the 24th of April 2019, rather than presenting them.
What you could say, you've got to be a bit careful about the act proving the crime or words like that, because this is an example of circumstances, so you've got to be a bit careful about it.
Oh, yes.
But I think what you're saying is we look at his statement, second statement.
Yeah.
And D2 says, I had no reason to think they wouldn't be honored.
Yes.
And if it rested with that, I think you might struggle if it rested there in persuading me that that didn't amount to the same thing as I thought they'd be all right. I know you pick up on the wording.
Yes.
The point you make is what follows rather undermines that defense, because insofar as it suggests, I thought they'd be honored on the basis that the money should have been paid to D1, in which case there would have been money in the account. You say, in fact, holds the potential explanation below the waterline.
Precisely.
I think that's the high watermark, so to speak, of your case.
Yes. You've put it exactly as I have put it.
See,
I quite accept that.
If somebody says, well, clearly I believed there was money, that goes some way to answering you. But if that belief is premised on a contention which couldn't work,
Yes.
because those were the very circumstances the checks were designed to guard against,
Precisely.
then there's a problem.
Yes.
It might not get you home in the end, but you say it gets you as far as an amendment.
I say it raises a good arguable case, which is what I've got to do. It's certainly not fanciful. It's a proper case, and it demands an explanation. And I fortify that by saying it demands an explanation, and the defendant has taken the opportunity to put in a defense where he hasn't advanced a positive case. He's put in a statement that contains an inherent unlikelihood / impossibility. And he's never established, and he's never said for certain that he had the money or where the money was coming from or anything else.
Yeah.
Put another way, I ought to be entitled to cross-examine him on this at a hearing. He'd never get home on a submission of no case to answer. That would mean that he'd be put to his election. And I'm entitled to be able to ask him about that. I'm also entitled to disclosure in relation to it, and disclosure will include his bank statements.
Let's not get ahead of ourselves.
Yeah, well, I'm not seeking to do that, but what I'm seeking to do is to show that at this stage, particularly in a fraud case where the claimant has been kept out of the knowledge, so to speak, I'm entitled to say good arguable case, demands to be answered. He's taken the opportunity of trying to answer it. The answer's no good. Please give me leave to amend, and then we'll get as far as taking further steps in the proceeding.
Yeah, I've noticed it's 1 o'clock.
Yes, thank you. I don't think I need to address you further on the checks. And the rest of the submissions should go relatively quickly.
Well, you've made them, haven't you?
May I at least check through the rest of my... Yeah, I probably have.
You dealt first of all with the... we have the shorthand version, historical costs.
Yes.
You've dealt with unrelated payments, and you've dealt with the checks.
Yes. What I haven't dealt with, and will deal with very briefly, is the effect of Article 2461 requiring good faith. I say that when you look at the Mid-Essex case, that the effect of that is not, as has been suggested by my learned friend. He read you the passage at paragraph 114.1. And I mean, I know he's had very little time to read these cases, and this was a case that I put in. And this is now really thought to be the Locker's Classic on good faith, I suspect, because it comes from Lord Justice Jackson, whose judgments on these matters are always impeccable. But he didn't read you 112.
Hang on.
In the context, this is the paragraph 112, and I haven't yet had time to put this in a numbered bundle.
Okay.
Paragraph 112, in the context of clause 3.5 of the conditions, the obligation to cooperate in good faith, in my view, means the following. The parties will work together honestly, endeavouring to achieve the two stated purposes. And then at 114.1, there's no finding by the judge of trust was acting dishonestly as opposed to mistakenly applying the provisions of a complicated contract. That's repeated at 116.1, no finding by the judge and so forth. And for those reasons, the Court of Appeal find there was no breach of the obligation to cooperate in good faith. And my submission is that when taking all the cases as a whole, the obligation to act in good faith means no more nor less than the obligation to act honestly in relation to your obligations, your other obligations, and to conduct your dealings with the other contracting party in an honest, i.e. not dishonest fashion.
If you
Now,
get home on fraud for the purposes of an amendment, this interesting debate doesn't really arise.
no, it doesn't. And indeed, it is only put in as a supporting argument for the main argument that I've established a prima facie case of fraud in any event. But it also assists in my assertion that fraud in the conduct of a contract, in breaking a contract, makes the individual agent liable, where the individual agent is a manager or the controlling mind of the company, personally, and liable in his personal money, as it's put in the cases and in the statutes, as well as the company.
But not whole breach of contract.
Sorry?
He's liable for his fraud.
Well, that's the nub of the issue here, and I disagree that he's liable only for his fraud personally, in much the same way as the English tort of deceit for the deceit, just as in the other case I relied on, the inter-export case. The inter-export case, incidentally, was a case between a company and two individuals for the deceit of fraudulently persuading inter-export to sell sunflower oil to their company, which was called NTL. The two 50% shareholders, one of them being a director, were held liable, personally liable, for deceit. And that was an example of deceit where it wasn't necessary to pierce the corporate veil. The importance of the Dubai Court of Cassation case that I mentioned to you and cited to you was that in the UAE, in Dubai, a director is liable for breach of contract if he handles his relations with the other contracting party fraudulently. And that was the passage that I read to you, which I think was at
Let me
page
go
3.
back to that, because I didn't
Yes.
read it. Not sure I noticed that.
Well, that was my, yeah, that's my point on it. Speaking from memory, would you give me a moment to find my, here we go. So it starts at I397,
Hang on.
and the relevant page is at I422 and 423.
Let's get back there.
I think it's I422. It's the page that starts at the top with the words "has flaws" and
Yeah.
must be nullified.
Just bear with me for a moment, if you do. Okay, I'm at 422.
Is that the page that's headed "has flaws and must be nullified"?
Yep.
Yeah. So it's the whole of that page. The third line, or from the second line, the manager of the limited liability company is the one who manages the company. And if he carries out a disposition with third parties, and we say that must mean a contract, and it's clear it does from the rest of the page. The rest of the page makes it absolutely clear. And for its account and within the limits of its activity, the company is solely bound by the effects of this disposition. It's also sustained that the manager of the limited liability company shall not be liable, it's liable, again, in contract, in terms of his own funds, except in the event that fraud or clearly apparent deceit is sustained. And then it goes on. And then a few lines on, it is also established the contract is originally or directly concluded and may be concluded by authorization unless the law requires otherwise. And going down the page, but it's important to read the whole of the page.
It doesn't say. Okay.
Well, I think it does. If the agent contracts with a third party in the name of his principal,
Yeah.
either, yes, and
Yeah.
for his account, then the effects of the contract and the rights and obligations arising therefrom do not affect him,
Yeah.
but rather affect the principal.
Yeah.
This is the general rule. In the
Yeah.
light of the above, the judgment of the first instance endorsed by the challenge judgment had grounded its ruling in this regard by not accepting the case against the second and third respondent, according to the reasons stated therein, that the second defendant acted as a representative and deputy of the first defendant company. So that's the general rule.
Yeah.
Principal only liable. It was not proven that he committed a personal mistake or acts of fraud.
Yeah.
Therefore, the effects of the contract do not affect him, but rather affect the company solely. So that elaborates what's said higher up the page.
Sorry, Lord Buck. Nowhere
Yes.
here is there a consideration of what he would have been liable for. This is not an authority for saying he's liable for everything.
No, he's only liable for fraud. He's only liable for breach of contract in the case of fraud.
No. Okay. Let me give you a
Unless I'm misunderstanding you, and I'm sorry if I am.
Well, you might be, or rather, I might not be putting it well. Let's assume D2 was fraudulent in the three respects you have set out.
Yes.
So that's the checks, the unrelated invoices, and the historical costs.
Yes.
Let's assume that D1's contractual failure, let's assume that in total, those three matters amount to X.
Yes.
Let's assume that the company D1's failures amount to 5X.
Yes.
The question is, assuming you get a fraud case off the ground, is his potential liability X or 5X? I don't read this judgment as saying he's liable for 5X.
Oh, no. Because it says quite clearly, in the case, shall not be liable in terms of his own funds, except in the event that fraud or clearly apparent deceit is sustained.
Sorry,
so,
liable for what?
Well, then it goes on.
Yeah.
Fraud and clearly apparent deceit are not presumed. It must be alleged and evidence must be sustained. I would concede that that limits the damages for which the individual defendant is liable to the extent of the fraud that is established.
Yep.
And that seems to me to be the correct interpretation.
That's what I was seeking.
Because the individual, but he's liable for, under the contract.
Doesn't matter, does it?
Well, not if Mr. Carnell's wrong, but if he's right, that was the important.
The point that's lurking there. As far as I'm concerned, if you get a good arguable case off the ground, you get leave to amend in terms of fraud.
Yes.
If you persuade me on all those three matters, then potentially he faces a claim personally for those three matters.
Yes.
To the extent they go.
Yes.
If D1 has additionally wholly failed to perform its obligations in 10 other respects, well, tough, you have to go against D1.
I agree.
Right, well then, I just wanted to be clear about that.
I agree, and if were Your Honour to grant leave to amend on condition that we should limit our claim against D1 to those areas where we say his behaviour is tainted by fraud, I would be completely content with that limitation.
Just say that again. Grant leave limited to those areas where behaviour tainted by fraud.
Yes, that would seem to me to be the correct interpretation.
Thank you.
of
That's
that.
or I was just concerned you were saying something more.
Yes, I now understand that you were suggesting that I might be.
You might be saying he's liable for the entirety of the contractual losses, which didn't seem to follow from the decision you cited.
I agree, and it would be unjust.
I agree with that.
I can just see what other points.
Well, you've got this tort claim. What does it?
Yes.
I mean, firstly, does the UAE have that tort? Where you've got the spectacular double negative.
The double negative is a creation of Mr. Carnell's submissions rather than all I said.
I don't know. I think that's modesty in authorship. I think it appears in your document, and he understandably relied on it. So
Yes.
I have a couple of questions. A, is it part of UAE law? And B, what does it add if it is? And if you succeed on fraud, you don't need it, and if you don't, it doesn't help.
Yes. I understand that. I mean, it does seem to me that it's sensible to include it.
Yeah.
And
you know,
you are right that and I invite you to look at this separately, but the version of the articles or the translation of the articles 282 and 283 is different in page I-117 from the one that appears in my skeleton. I might say the one that appears in my skeleton, I don't know, because I didn't do the translations and I didn't produce the translations. But,
I'll accept from Mr. Parnell that the difference is no doubt due to the differences in translation.
Yes, and if you look at them carefully, you can see why the two are different. And it's just the one in my skeleton that uses a slightly more modern English. So the one in my skeleton says, Article 282, any harm done to another shall render the actor, even though not a person of discretion liable to make good any harm, rather than author of any tort, if not discerning, should be bound to repair the prejudice.
But how does that get the tort of tortious interference into UAE or DIFC law?
Because it is plainly a wrong committed by a person, just as deceit is a wrong committed by a person.
You've got to be very careful here with respect. I mean, not too long ago, a DIFC Court of Appeal of which I was a member, held that certain other torts were not part of DIFC law.
Yes.
You've got to be rather careful about it.
I think it is. I think it's slightly confusing because here there is a difference in the translations.
Yeah.
Because any harm done to another shall render the actor liable to make good the harm.
Yeah.
Mainly covers
the world.
Covers the world without limiting it to a defined category of torts.
That's not going to get you.
The difficulty we have is that tort in the code is of itself undefined. So the best I can say is this is a harm, and it is capable of being argued as a good arguable case and not a fanciful case, that there is such a tort in the UAE, or that such behavior is a tort in the UAE.
Is that your best point?
Well, that's always a very pejorative question to ask, if I may say so.
No, it's not meant either unkindly or
in a sense, as you point out, I say rightly, but I didn't know this, but where the DIFC Court of Appeal has ruled, with you among their number, that particular torts were not torts known to the law of the UAE, That was because counsel for the claimant made the case, which presumably was a good arguable case, or he wouldn't have, or she wouldn't have made that case, that there was a tort, and it took the determination of the Court of Appeal of the DIFC to determine, against him or her as it happens, that there was no such tort known to the law of the UAE. I cannot establish a definition of the word tort that encompasses the tort of tortious interference or inducing a breach of contract, any more than Mr. Carnell can establish that that is an excluded tort, because there is no wider definition of tort and because we're governed by the terms of the code.
Well, it only matters if you're wrong on fraud and you need it.
Yes, in practice. I accept that. But it's at the same time, it should also be open to me to argue it. And if you're giving if you were minded to give me leave to admit to amend on fraud, then it would be sensible to give leave to amend to argue this point on the existence of a tort of tortious interference, because it meets the test of a good arguable case. And
Okay.
is not. That rejigged is, I suppose, my best point on that.
Thank you. I had no wish to be discourteous.
Nothing else. So I'm so sorry.
I had no wish to be discourteous.
No, you certainly weren't. The only other point I'd make, and I think I may have made it in the course of my submissions, is that I've pleaded the behavior of Mr. Affan as fraud and dishonesty rather than as the English tort of deceit, because it seems to me in pleading it that properly reflects the UAE authorities and the UAE code, because once you've got the company's law, including Article 84 and Article 162, on which I do rely, then it's important to use similar language, because it's my submission that Article 84 and Article 162 fortify my submission on the contract and fortify my submission also on individual liability. And I know you've picked up the point because you said so in discussion with Mr. Carnell, that the way we put the case is that those two articles give rise to contractual liability as well as to tortious, as well as to statutory liability. As you've pointed out several times in my submissions, it probably doesn't matter, because if I get home on fraud, I get home anyway. But it's...
Well, there's another reason why you may be wise to do what you've done in terms of looking at the code language. I'm not sure from recollection that there is a tort of deceit in the UAE law.
That's another point I was going to make, yes.
Which may not help you on your tortious interference point, but it's just one of those things.
By parallel or analogy, maybe you may be right, but at any rate, it seemed to me that deceit was an English concept, and that although the word deceit is used in some of the authorities, the essence of the authorities in the UAE is fraud, and fraud, well, I would suggest, rather defines itself. I don't think I need to say any more to you on our case on jurisdiction and the application of NEST, because we've dealt with it peripherally, I think, as far as it needs to go.
Okay.
And that, I think, is all I need to say. And I'm sorry I've gone on a little longer than I intended.
No, you had a degree of interference.
Discussion.
Thank you very much. Mr.
Thank
Carnell,
you very much.
Thank you, Lord Fox. Mr. Carnell, your reply.
Could we possibly have a 10-minute break, please?
All right. If you'd like one.
I would actually, yes.
You got it? Thank you very much. We'll resume just after 19:30, if that's all right.
Yes.
Thank you very much. Thank you. I'm sorry I disconnected myself when I was trying to connect myself.
Well, if that's the worst thing you do today, so it won't be a bad day.
Thank you.
I'm not going to be very long. I think I'm assuming that Lord Marks is ready with his team. I would propose making a start.
Yes, please. I see Lord Marks there, so
Yes, I'm ready.
thank you.
I'm going to try very hard not to repeat myself in any respects, but the question that really struck us, having heard Lord Marks's very eloquent submissions, is where is the fraud? It's entirely unclear to us what the basis of the claim in fraud is really supposed to be. And let's take as let's start with the so-called historical costs claim. Now, we've set out our position at some length in paragraph 6.3 and following in the defence, and those points you will see depend in large part on timing. Now, Lord Marks pooh-poohed that at some length, and started off with page H158. I hope I've taken the reference down correctly. This is the letter of the 26th of November 2018. Now, that's before the addendum agreement, and it's well before the payments, the dates of which are set out in the draft defence. Now, Lord Marks said very clearly that this letter connotes payment. Well, if you look at what is said here, it says project cost incurred. It doesn't say paid, and incurred and paid, I would respectfully suggest, are entirely different things. Now, we must remember that before we get too precise about construing words as if they were in Hansard, we should remind ourselves that most of the people involved in this project are not native English speakers. But you can test that point with the fact that this is prior to the addendum agreement, which was in mid-December. The whole point of the addendum agreement was that it was intending to pay monies towards historical costs, which at that time had not been paid to Affan. So, as far as Lord Marquis's complaints about the historical costs are concerned, we disagree quite strongly. The second point is the what we will call the shuffled materials. This relies heavily on the mysterious Affan project manager, who isn't named, about whom we know absolutely nothing, and in respect of whom we have absolutely nothing to go on. Now, this isn't an instance where someone is saying Affan forged delivery notes or Affan forged invoices, or the entire basis for Affan's claim is bogus. It is being suggested to us on the basis of an unknown third party.
Did you complain about the third party being unknown?
I don't believe I did.
No, because had you done so in your opening, I would have asked Lord Marks about that. So I will.
Sorry?
So I will in a few minutes.
Thank you. Well, it's my oversight. I make no bones about that. But the point here, and this is a point which is made by Dr. Affan in his second statement, is that the materials for the Museum of the Future were for the most part generic. And your point concerning widgets, if I may put it this way, was absolutely spot on. And I mean, all I can say is that as a basis for a serious allegation, this is about as thin as it gets. As far as the checks are concerned, again, one can be overly precise about the way in which one construes witness statements, to the extent that Lord Marks is relying on a double negative, and it's not the first time this afternoon anyone has relied on a double negative. Then the fault rests with me. But what Affan is saying in his statement at paragraph 1.4, and I can go to it, but I don't think there's any great usefulness in doing so, is that he was saying that he believed, or had no reason not to believe, that these checks would be honoured as the project proceeded. Now, what we were then told was that this is a circular argument. Well, with respect, it isn't. The point here is that, and the reason that it isn't, is because what Lord Marks said to you was that the checks only become presentable if there has been a default. Now, what we don't see, and it's paragraph 21 in the draft particulars of claim, is any detail of what that default is supposed to be. Now, that you have rightly said that, of course, what we have before us is extracts from the case that will be put forward. But you would rather expect that this was a hole which would have been filled in order to demonstrate the basis on which the checks were to be presented. Now, of course, while it may be that in due course Lord Marks will be able to establish defaults, at the moment he hasn't made any effort to do so, not one. So
I'm not sure that's fair. Well, what Lord Marks says, forget about the particular sentence. I'm not too fussed about the negatives in this. What he's saying is, reading the thing broadly, paragraph 1.4, it starts with this sentence, okay, let's get over the hurdle that it might have been more positively expressed, forget about that. But he then says, it reads naturally, well, I thought they'd be all right, because I expected the claimant to keep paying D1. And Lord Marks's submission is, but the claimant wouldn't be paying D1 in the circumstances in which the checks were needed. That's really what it's about. And your man, Mr. Cornell, if I can put it that way, the second, hasn't done anything at all to say, well, here's, I've got endless funds available. You know, look at my financial standing, etc. Now, it may well be, bearing in mind this is purely an amendment application, that in due course, all those points can be made. But to say Lord Marks hasn't done anything in that regard, I don't think is quite right.
Well, I don't want to be.
I know you're not aiming personally at him.
No, absolutely not. And that would be that's the furthest thing from my mind. But if I may say so, this is an instance where the burden of proof rests with him.
Mm-hmm.
It's up to him to show that there are circumstances in which it was permissible to present the checks, and that there was. Now, I accept entirely that in the ordinary course of events, a security check does not get presented unless there is a default. That is obviously the case. And in that situation, it is for the claimant to show that there has been such a default, such as to justify them in presenting the checks, and that's where the hole, if I can call it that, appears. Your Honour looks as if he's about to ask a very searching question.
No. That's elevating my state of mind beyond where it is. I was actually trying to make sure I'd successfully noted what you've just said.
I do beg your pardon.
Very kind of you to put it the way you did.
Well, what you should also be aware of in paragraph 1.4, and I'm sure you'll note this when you reread it, is that what Dr. Affan says is that he didn't know when the checks were going to be presented. He had no way of knowing that. He had written to the claimant indicating in the 24th of April letter the difficulty which he faced, and nevertheless the checks were presented. Now this takes us back to the point which I raised in my submissions concerning the ingredients under UAE law for fraud to be shown, which is that there needs to be some action on the part of the person committing the fraud. Now, in this instance, Dr. Affan doesn't know when the checks are going to be presented. That's an action taken unilaterally by the claimant. So on that basis, there is at the very least a question mark as to whether this can constitute a fraud for the purposes of UAE law. I'm just going to deal with a couple of other points. The first of those is tortious interference. I would respectfully associate myself completely with everything that Your Honour has said. We haven't been told on what basis a tort of tortious interference exists. And while, of course, my learned friend said, well, I haven't shown that there isn't one, again, not my burden of proof. The other points which I was going to raise, the possible concession to limit leave to amend to any matters which are tainted by fraud. We merely say that you should be very, very careful indeed to find that there is a good arguable case on fraud, and it's very much the case, and we've been uphill and down dale, if I may put it that way, on the test to amend, but we say fairly and squarely that this claimant has not come anywhere close to demonstrating that it has a good arguable as opposed to a merely fanciful case. We have a great deal of material which seems to hypothesize that if certain pieces fall into place, then they might be able to establish fraud. Well, that, with the best will in the world, is really not good enough. And the last thing I was going to say is that there has been a significant absence of any discussion of harm. Now, the claimant has accepted, and I've taken you to the relevant bit in its skeleton, which is paragraph 34, that the need to establish harm for the purposes of establishing a tortious claim. I made submissions earlier to the effect that they haven't shown that, and I'd also made submissions to the effect that having cashed the first defendant's bonds, there was no way that they could show that they have actually suffered any harm. Now we haven't heard anything about that. Now whether that was due to the pressures of time or not, I don't know. But we certainly haven't had anything about that. That was really what I wanted to say. Would you mind if I just checked with my team?
Please do.
Hold on 1 second. I'll just mute myself.
I will stay here if I may.
I have duly checked, Your Honour, and there is nothing else I want to say.
Well, Mr. Cornell, thank you very much. You will hear in a moment what I'm putting to Lord Marks. It's quite difficult with these linked applications to know who has the last word. I'm not going to shut either of you out from saying something you particularly want to say. My instinct for Lord Marks was that there were two matters which we might want to deal with, probably only two, not because I'm stopping him on anything, but simply because these are the two matters that occur to me haven't been dealt with. One is the fact that on the shuffling point, or the unrelated costs, you make the fair point that the project manager is currently anonymous, and that's always a cause for concern. The second point is the no harm point because of cashing the bonds. If when Lord, you want to add a sentence yourself, fine. But if you do, Lord Marks might have a chance to add another sentence. So we need to decide which we draw. Anyway, those were the two questions I had for Lord Marks. If he wants to say anything beyond those 2 points, he'll no doubt say so. We'll see where we are.
Your Honour, yes. May I just respond first then to the identity of the commercial manager, and to remind you actually of paragraph 27 of the draft particulars of claim at H33, because I say that does actually identify her by her job.
Para 27.
Oh, 27.
Just hang on a moment. Paragraph 27.
Yes, page H33.
Oh, yes, yes. Sorry, I made hard copies.
Right. So it says the first defendant subsequently admitted the fact that such payments are being claimed from the claimant by the first defendant through the second defendant in respect of materials bought for other projects unrelated to the subcontract. The first defendant's commercial manager, it wasn't project manager, confirmed to Mr. Doyle that second defendant had instructed her to issue the claims documents to the claimant,
Okay.
knowing it did not
Who-
support the claimed amounts and were unrelated to the subcontract. She said she felt she had no option but to do so. I've taken instructions over the short break that we had, and that was Thanuja Jayan, and we've come across her as the defendant's commercial manager.
Can you
If
just
I can remind you that she was the signatory of H320, which was the document of the 8th of January, immediately following or 2 days after the meeting between Mr. Affan and Mr. Doyle. And she also signed H308, the 10th of January.
Okay.
And in both, she is named as the commercial manager. So she plainly knew all about the substantiation required because she refers to that substantiation and the supporting documentation.
Good.
And if that is right, it is not conceivable that she could admit that, assuming it was truthful, on the basis that there was a legitimate operation going on of moving goods from one project to another, because she would have known about that, and that would have been an explanation that would have supported the claimed amounts. And she says there that Mr. Affan had instructed her to issue the claims documents, knowing that they didn't support the claimed amounts. She felt she had no option but to do so. And we say, therefore, that's powerful evidence. On the second no harm point, because they cashed the bonds, that really doesn't wash, because the bonds were performance bonds and so forth related to the whole of the contractual performance. And they supported or remedied or made good the default in part in respect of all the breaches of contract, which were myriad, alleged against the first defendant. They do not make good the damage specifically caused by the fraud of the second defendant. What I do accept in relation to that is that the historical costs claim and the checks claim overlap, because the checks were guarantee checks in respect of the historical costs. And of course, the fact that they weren't honoured caused the same loss as the failure to pay the historical costs. So that those are coextensive, but nonetheless separately recoverable, but you can't duplicate the recovery, that's all. That, I think, is the 2 points that I wanted to deal with that you suggested I should. I would make a third point, which is that this difference between incurred and paid would be a good point as barristers negotiating brief fees, or whose clerks negotiate brief fees, certainly know, because fees are incurred before they're paid. Nevertheless, that is given the lie to in this case by the fact that the claim is for April to July invoices and is said to be against a document requiring substantiation and describing substantiation following a meeting with Mr. Affan on the 6th of January and prepared on the 6th of January that required not just invoices, but proof of payment. And there has never been any argument but that that is a genuine document and a genuine reflection of what he agreed. In
Can you
those
just remind me of the reference to that document? I'm
that document it's actually reproduced in our skeleton, but it's also at page H304.
Good.
Sorry, it's reproduced in Mr. Doyle's statement at H53, and the document itself is at H304.
Thank you. Thank you very much. Anything else?
I think that deals with the
Right.
deals with the response I'd like to
Thank you
make.
very much. Mr. Carnell, is there anything you want to add to that? Bearing in mind that I'll probably then ask Lord Marks if he wants to say anything.
Only in relation to this this final document. This is a document emanating from the claimant. The claimant's position, in essence, is to say, we asked you for substantiation. We are entitled to rely on this document because we say so. It frankly does not prove anything at all.
Yeah. Right. Unless Lord Marks, you particularly want to add anything.
Well, paragraph 56, it was of Mr. Doyle's statement on H53. It was effectively explained to Affan without any complaint.
Last shot, Mr. Cornell.
No, I think I've probably said all that you want to hear.
Very good. Well, could I say my thanks to the registry staff who've looked after us all the way through. Much appreciated. My thanks to you both for your respective submissions. Very helpful. I will take a little time to produce this, so please bear with me. Tomorrow, only so we don't go and lose track of it, I'd be very grateful if someone uploaded the authorities in the law report form. Those are today's authorities. And if you could put that onto the e-bundle, that would be most helpful. Otherwise, I think that's it for today, unless either of you have anything else to add.
Thank you, Your Honour, for your attention and patience.
No, not at all. In fact, we can all congratulate ourselves. We have 1 minute to spare within the 4-hour estimate.
How shall we use it, Your Honour? Thank you very much
Indeed, shall we use it? Thank you both very much.